It's her fault. It's her fault. It's her fault. Ah!
That was a good intro, too.
Yeah, you guys just missed the best intro I may have ever done. You have missed... Oh, I'm furious. I have to have it muted at the beginning. Will you get out of my room? It's Lady Rackets has foiled every plan. Welcome to Lawsplaining the Interwebs. I am your host. Welcome, squad. I am your host, Nick Rekieta, the most aesthetic host of the most aesthetic legal podcast on YouTube. And if I'm not the most aesthetic, I'm the most aesthetic one that is worth watching. And if you go back and lip read, that is what I said before. Thank you, Jason Benaim, for saying my mic is muted. I found that out from you and the giant spam of chat. Dominic Peluso says, "Dear Tess, poo and pee, poo and pee." Guys, I gotta tell you, Sean deleted my technical ability, I think. I gotta tell you, I think I got the Hawking's curse because I made fun of Stephen Hawking's yesterday, and then all day today, I have had trouble, like, even moving around. I've been exhausted and my limbs have not worked. So, you know, the Hawking curse is real. Now that he is freed from his cage that we locked him in for 76 years, he is out to terrorize the earth. And you should all be very cautious about mocking him because you may be stricken as well. So, enough jokes. Enough jokes. Today, something, I mean, completely unexpected to me has occurred. I had no idea this was coming. I can't believe it now that it's here. Every single word I read runs red-hot rage through my body, and I honestly don't even know what to do with this. This is the juiciest document drop of the lawsuit, and it comes straight from Landau. And just so you know, I am drinking orange juice tonight because I'm pretty sure that Maddox is trying to kill me. Ketchup Pizza says he got paid today. Here's 1/16 of a bottle of Lagavulin. Thank you, buddy. I really appreciate that. All right, guys. So here's what I'm gonna do. This requires severe attention. And I know a lot of people really want this information from this document. So I'm going to do this live stream a little different than the other ones, okay? And I'm going to ask you guys to help me out with this. I am going to, thank you. I am going to start ignoring the chat for this one, unless it's a super chat, just because I want to plow through the documents on the front end, okay? And we're going to go hot through the documents. If you have a super chat, or you really have a question that you want answered right away, send me a super chat and I will answer it. If you have a question that you don't want to super chat, that is fine. We will do Q&A for all of this stuff at the end of the plow through. I will announce when we're done with the documents, and then you can ask any questions. So if you don't want to, same thing, I'm not going to require a super chat to answer a question, but I want to give the people who are going to listen to this later the opportunity to get a front load of all the content, or as much of the content as possible, and kind of respect that format, because this is a document drop that people do not want to miss. Thank you very much, GigaWarp, for the super chat donation there as well. This is something that people don't want to miss, so I'm going to try this out and let let's give this a shot on this one. And then, you know, we'll probably go back to regular for the next one. Jesse Samuel Anderson says, waited for this all day. Love you all. And I do too. And I have been, I mean, since these documents dropped, I have been busy for most of the day since then. And I'm just happy to finally get to vent about this stuff, because this is, I mean, I don't even know what to do with it. I don't even know what to do with it. So, all right. As of right now, I'm going to only read super chats that pop up. And then, like I said, once we get through the documents, we will have time for a full Q&A session. And if she's feeling like it, I'll bring Lady Rackets in. And we can have our general live chat fun, but let's get through these documents. And I'm going to do them tonight in chronological order. So we are going to start with the Greenberger letter to Landau and everybody else. We will then go to the Munoz letter. Nels Eklund, I will have the audio from yesterday up very soon after this stream. Oh, this isn't a super chat. Don't make a liar out of me. I will have the audio from yesterday up right after this stream while this is processing. And then when this is done processing, I will have the audio up from tonight up as soon as I can. So that hopefully answers your question. Okay, so like I said, we're going to go to the Greenberger letter first, then the Munoz letter, Munoz from Weber Shandwick. Then we're going to read Landau's letter. And then we have... notice motion. Do I not have Greenberger's response? Oh, I got to get Greenberger's response letter. Will be up after Landau's letter, then Landau's notice, then his memorandum of law. So that is the order of the documents today, guys. And we are about to jump in. And just in case anyone is wondering, and this is maybe the most important part, random consonants in my speech. You can't see it now because this isn't a text format, but random consonants in my speech are replaced with a comic version of the letter B. So we're going with that as well. So just remember in any sort of mental transcript that you may have, that's going on. So we're going here. Exhibit 1. This is chronological Greenberger's letter to everyone. Let's jump right into it. So, this is to Kevin Landau. As you know, I represent defendant Asterios Kokkinos in the above referenced action. On March 8th, 2018, you filed an affidavit executed by Mr. Orangutan in which he admitted that he posed as Heather to communicate with Mr. Kokkinos' employer. And a super chat from Oxygen Induced. You have an Ardberg typo in your Patreon goals. It says Ardberg. I hate to be that guy, but I'm being that guy. Ardbeg is delicious. Okay, I will fix that immediately. That is very important. Thank you for letting me know. Guys, I'm not opposed to criticism or above it. Ed Chambers says, Boss Merhout sends his regards. Maddox's wallet is sleeping with the fishes. Yep. So here we go. Back to it. Yeah, NYSCEF document number 101 at Exhibit 3, the affidavit. The affidavit contradicts Mr. Orangutan's previously verified allegations. In the affidavit, Mr. Orangutan also admits to criminal conduct. I am sending you this letter pursuant to Rules 3.3A3 and B of the New York Rules of Professional Conduct and Uniform Rule 130-1.1. In short, if you do not take steps to remediate Mr. Azunian's conduct, then we intend to do so. And note the language here. This is a lawyerly way of writing these letters and dealing with these things. We intend to do so is not we will do so. And that matters. That matters as far as this goes. Brett Anderson and Andreasen, will the other two lawyers have similar letters ready, or will this put a stop to those going? Munoz's letter, I don't know. I don't know if they're going to join in. Probably not. Kevin Flesher, I'm only super chatting to interrupt Nick reading. Thanks, buddy. I appreciate it. But it's important to note that when he says we intend to do so, that does not mean we will do so. And that's a distinction that will matter in a little bit in regards to Landau's memorandum. So bear that in mind. And as a pro tip, If you're looking to become a lawyer, when you're advising clients on how to properly threaten people, don't ever say you will do something. Say that you mean to do something, intend to do something, you will consider doing something, you will look at your options, you will pursue all avenues for a remedy, you know, that sort of thing. Don't ever specifically say what you're going to do, because you might change your mind. Okay. Plaintiff's complaint includes allegations about an individual named Heather, who communicated with Mr. Kokonos' employer, Weber Shandwick, in an attempt to get him fired. Complaint 64 to 69. Plaintiffs then alleged that Mr. Kokonos posted online about the incident and threatened, quote, to continue harassing plaintiff Mr. Orangutan unless he apologized for something plaintiff Mr. Orangutan didn't even do. On at least 4 occasions, Mr. Orangutan executed and served/filed affidavits stating that he had read the complaint and verifying the allegations as true. In other words, Mr. Orangutan has repeatedly and under oath represented to the court and to the defendants that he was not Heather. In the affidavit, however, Mr. Orangutan states under oath that he was, in fact, the individual who had posed as Heather and communicated with Mr. Kokonos' employer. Both the affidavit admitting to being Heather and the verified allegations denying that he was Heather cannot be true. Plaintiffs have offered material evidence that is false, and you, as their lawyer, now on notice of the falsity, have an ethical obligation to take responsible remedial measures. See Rule 3.3A3 of the Rules of Professional Conduct. And guys, I'm not going to pull up the rule, but looking at the rule, it does say that even if this is privileged, the lawyer has an ethical obligation to disclose the falsehood, even if if that is contained in privileged communication between the lawyer and the client. They still have to disclose that falsehood. This rule it's a serious ethical violation to knowingly put a falsehood upon a tribunal. And this does qualify as a tribunal. It is unclear what remedial measures you can take other than to disclose to the court. See comments 10 to 11 in Rule 3.3. If the affidavit is true, and Mr. Orangutan did send the Heather emails, then in addition to committing perjury, a crime, Mr. Orangutan has also has committed the crime of criminal impersonation. New York Penal Laws, Section 190.25. Again, you, as the lawyer and as the officer of the court, have an ethical obligation to take reasonable remedial measures, and it is unclear what measures you can take other than disclosure to the court. See Rules 3.3b of the Rules of Professional Conduct. I respectfully urge you to review Rule 3.3 of the Rules of Professional Conduct, as well as any ethics opinions interpreting the rule. These include, without limitation, NYSBA Ethics Opinion 837, 980, 1123, 741, and ABC NY Ethics Opinion 2013-2. I also respectfully remind you that assertions of material factual statements that are false constitutes frivolous conduct. Uniform Rule 130-1.1c. Frivolous conduct is relevant to the idea of sanctions coming from the court. If you engage in frivolous conduct, you are, as the attorney, you can become liable for sanctions. So that's the meaning of that little line there. In light of the pending motions, we request that you disclose the issue to the court within the next 5 business days. If you do not take these remedial measures in that time, then we intend to take the appropriate steps to notify the court ourselves. This letter is without waiver of or prejudice to any of Mr. Kokonos' remedies or defenses, each and all of which he unlimitedly reserves. Thanks for the super chat, X Mickey G. Sincerely, Jordan Greenberger, Esquire. And he has CC'd the counsel for the other defendants via email. So there you go. There is the Greenberger letter in its entirety. It is professional. It is scathing. The apostrophes are in the right place, although he must disagree with me about needing an S after the floating apostrophe on Kokonos. And man, Greenberger, if I ever get to meet you, I'll buy you a drink for that floating, that empty S. I think it should be there. Ben Lenigan says, what have I missed, please? You've just missed the Greenberger letter, and we are moving on to the Munoz letter. Go back and listen to the beginning. when we get done here. Kellen Steck says, just want to make sure you say queef since I don't think you have ever said that word on stream before. I doubt it. I doubt it, but thank you for the opportunity, I suppose. All right, so on to the Munoz letter. Munoz. Does anybody know? There's no Enye. Is that an Enye? Little squiggle over the N? I don't know if it's Munoz or Munoz. I'm sure if you tell me over chat, I can tell. Yes. Okay. I'm ignoring the chat. You guys are on hold from me. Whatever 3241 says, can they send another like this, except it is asking Landau to disclose that Maddox is a cuck? Yes, they can send that. That would be good. Dear Kevin. Guys. Okay. If you have not noticed from the beginning, Weber Shandwick appears to... So it's Munoz. Okay, so I'm going with Munoz. Weber Shandwick does not seem to like Kevin Landau. So if you notice, Greenberger, Dear Mr. Landau, it's called a tilde. Okay, it's pronounced... Thanks, Kevin Flesher. Oh, my goodness. Thank you, Rydog, for clarifying that it's a tilde. And Kevin Flesher says it's pronounced Munoz. So we have Dear Mr. Landau from Greenberger, and from Munoz, we have Dear Kevin. Dripping with disdain as their initial document was. And this is why I cannot wait for their response. I cannot wait for their response because they disregard Kevin Landau, as he should probably be disregarded at this point. Big Seti says it's called an Inye if it's a tilde on top of an N. Thank you, guys. I am not a Spanish. I am only lightly and French, mostly just English. Mr. Fish says, I thought it was Monoz. Monoz. Okay, so this firm represents defendants CMGRP Incorporated, DBA Weber Shandwick, and Joshua Kaufman, collectively the Weber defendants. In the above caption action, the Weber defendants join in the letter sent to you yesterday by Jordan Greenberger, counsel for defendant Asterios Kokkinos. Mickey G says, I can't be the only one laughing at the thought of that rat-faced Maddox calling Weber Shandwick and poorly faking a woman's voice. You're not alone, buddy. You're not alone. Yeah. And if you haven't seen it, the image on thedickshow.com, the fan art of Maddox as Heather is forever etched into my memory and still horrifying. Your complaint in this action, sworn to by both of your clients as true and correct in multiple affidavits filed with the court, misrepresents that the individual who exchanged a series of emails with the Weber defendants in February 2017 was not either of your clients. The complaint refers to, quote, an individual named Heather, in quotations, indicating that the individual's identity was unknown to you and your clients. States that Heather was writing a journalism piece. Notice the proper use of semicolons here. Landau could take notes on this. States that Heather was writing a journalism piece and attributes authorship of various emails to Heather. We now know that these assertions are untrue, that the complaint's obvious implication that Heather was a third party is untrue, and that your clients knew that each of these misrepresentations was untrue when you filed the complaint and when they swore in subsequent affidavits that the complaint was true and correct. We also know that Mr. Azunian deliberately disguised his identity and misled the Weber defendants when authoring emails under a fake identity, complete with fake media credentials and a bogus cover story about a planned media article. Mr. Orangutan's stated reason for engaging in these misrepresentations is similarly bogus. Even if, at some point, Mr. Orangutan had concerns about suffering retaliation from Mr. Kokkinos by revealing his true identity to the Weber defendants, and this claim is without any credibility, those concerns do not justify his continued deception following his assertion of claims against Mr. Kokkinos in this lawsuit. Thus, even in confessing his earlier misrepresentations, your client continues to mislead the court and the parties in sworn affidavits regarding his motivation for those misrepresentations. We therefore join Mr. Greenberger's demand that you take all steps required by New York rules of professional conduct to remediate your client's repeated misrepresentations to the court and to the parties in this action. The Weber defendants also reserve their right to separately seek sanctions, even in the event that adequate corrective actions are taken, and they should. Your complaint uses the Heather emails as the basis for asserting claims against the Weber defendants. You fools! You stupid, stupid fools! What were you thinking? This isn't some guy. It's not like a, I don't know, it's not like a FedEx branch or a local buffet. You're going up against a multi-million-dollar public relations firm whose image is their business, and you're going to call them out and you're going to lie about it in a discoverable lie? You stupid, stupid, stupid. Big Seti says, similarly bogus was my nickname in high school. Okay. Your complaint uses the Heather emails as the basis for asserting claims against the Weber defendants, and a material part of our motion to dismiss those claims is devoted to those emails and Heather's purported identity. Your client's continued deception has certainly prejudiced our ability to address the claims against the Weber defendants, and we are evaluating our remedies for this deception above and beyond whatever corrective measures you take at this time. This letter is written with express reservation of all of the Weber defendants' rights and remedies. Sincerely, Michael Munoz, and it's CC'd to the counsel for all parties via emails. Kevin Flesher says 40 effing countries. Absolutely. 40 countries. What on earth? What on earth was going through your head besides liquor, you moron? This is the Landau letter. This is the Landau letter. Jesse Samuel Anderson chats the anger. Dude, I am... This stuff makes my profession into a meme, right? Oxygen Induced says, we love it when you get angry. Thanks. Thanks. I don't know if my doctor loves it so much, but I will tell you, there are few things that can cure a down day, and just dripping anger is one of them. And I have been, I have not let it interfere with my day. I've let it energize me this morning, or throughout this afternoon, but I have been mad about this since I quickly skimmed the letter earlier. Or skim the memo. These letters are brand new to me, by the way. I have only skimmed the memorandum. I have not actually read through all of these letters. So this is as new to me as anyone who is listening fresh. And yes, this does make me rage, but please limit the chats to me to super chats at the beginning, and we will, again, for those who have started watching, because I've noticed the live counter has gone way up. In this one, the questions currently are being held for super chats only, and then after the documents are done, we're going to move into more of an open Q&A, like a regular live stream of mine. We'll still have that opportunity, but I want to plow through the information first and make sure people listening later get to front load the information that they're looking for, and they can enjoy or not enjoy the chat interaction that follows afterwards. H.S. Simmons super chats, a ramshackle affair. Yes, absolutely. So now, another ramshackle affair. This will be Landau's slap fight response, and let's see what he says. And guys, I might have to pause in the middle of this letter because I know what he's going to say. I already know part of it because it's mentioned in the memo, and it is mind-bogglingly infuriating. So, here we go. Messrs. Munoz and Greenberger. Messieurs? Did he go French on them? As it appears you are working in concert. Yes, that's what's going on. You dumb idiot. If they were working in concert, why wouldn't Weber just bring Asterios in? They have conflicting claims. They're obviously not working in concert. It would be easier for Weber to throw Asterios under the bus and get out of it. They haven't. To their credit. To their credit, they haven't done that, and that's probably because they can smell the dirt bag emanating off of you. Matt Asquith, Greenberger and Munoz are lit AF fam, hashtag squad goals. As it appears you are working in concert, I have composed the following letter to address each of your ridiculous correspondence that you didn't make it through a sentence. Received on March 12th and 13th, respectively. First, your contentions are disingenuous and approach unbecoming. You don't need a comma there. I suggest you stop listening to Kokonos's lemmings. Read, consider, and then if necessary, do your own research. Should they do research, Landau? Should they do research? Talk about asphalt calling the kettle black. I don't know if that works. Does that work? I'm going with it anyway because I wanted to say asphalt. The audacity you have of... Take out the you have. The audacity of sending a letter like that to counsel for everyone, threatening baseless criminal charges during an active civil litigation, is outrageous, defamatory. No, it isn't. And tantamount to an admission of unethical conduct by each of you individually and collectively. Nope. Nope. Oxygen induced. Is this like a toothless dog trying to bite RoboCop? Yes. Gary M. Cuss at them just this one time, please. Give me a minute. Give me a minute. We'll see if we get there. H.S. Simmons says, Coconut Lemming Squad, fam. Absolutely. I'm full-throated Coconut's Lemming Squad right now. This is... by each of you individually and collectively. It appears to have been concocted for no other purpose than to obtain an advantage, namely because of the extraordinary amount of liability your clients face. Kind of like you threatening sanctions if Dick Masterson didn't get his fans to stop talking about your DUIs, you drunk, grizzled pile of trash. See Rule 3.4e of the New York Rules of Professional Conduct, which prohibits lawyers from threatening criminal charges solely to obtain an advantage in a civil matter. They're not threatening criminal charges to obtain an advantage in a civil matter. They're threatening criminal charges because what your client did is criminal, you coward, and what you did. They won't say it as obliquely as I will, but you did. You did. You did it. You perjured yourself because you knew that Heather was Maddox. That's why you put it in quotes, you lying sack of garbage. Adam D says, Landau also got respectively backwards. Greenberger sent his letter on the 12th, Munoz the 13th. Good job. I mean, just the hits don't ever stop. Why is working in concert bad? Whatever 3241, it's... lawyers are supposed to independently counsel their clients, especially when they potentially have adverse claims. Like, you know, if Asterios was using Weber Shandwick's equipment without their permission, for example, Weber could throw him under the bus and say, whoa, we had nothing to do with that. We conducted an investigation and didn't find this stuff out. They could put all the blame on him. And similarly, Asterios could say, you know what, I checked with a manager at Weber Shandwick and they said it was fine, or whatever. They can make their defense based on the other person. And that might be advantageous. That might be advantageous for either party. And so they should not be working in concert. And if they are working in concert, they have kind of some duties of disclosure in regards to that. But they're not. They're obviously not working in concert because stylistically, they're different. Their claims are different. It wouldn't make sense for them to waste time working in concert anyway. It's just stupidity from Landau, par for the course. Alexander Hamrick says, I think they are able to smell the liquor from their offices. I think so too. So back to threatening criminal charges solely to obtain an advantage in a civil matter. Participating in presenting or threaten to present criminal charges solely to obtain an advantage in a civil matter. He's quoting Rule 3.4e, but that's not what they're doing. I know your analytical problems are manifest in every single document you write, but let me just tell you again, that's obviously not what they're doing here. They're pointing out that you have lied to the court, and they're asking the court, they aren't yet. They actually aren't. They're asking you to do your job and let the court know that your client's an idiot who lied Except, is he an idiot who lied? Or if you say that, is he going to come out and say, my attorney advised me to say that? Is that what's going to happen, you stupid coward? They're asking you to fulfill your ethical obligation and inform the court of the falsehood so the court can make the proper determination outside of the falsehood. If you don't, they will consider disclosing it to the court for you by asking the court to take judicial notice of your client's perjury. That's how this plays out. The court's already going to see the perjury, but they'll just draw the attention to it and point out that throughout this entire action from November, your client has been lying under oath. And man, I hope you're watching this, you scumbag. Ketchup Pizza says, drunk, grizzled pile of trash. Further, you are simply incorrect about the criminal charge you claim Mr. Azunian purportedly violated. A defendant cannot be convicted of criminal impersonation without proof that he assumed the identity of a real person. Like Heather S. at Condé Nast, you stupid, fat, dumb thing. Let's see. Let me see here. I don't even have it. I don't have the Heather S. LinkedIn pulled up. Okay, Heather S. If you're tuning in for the first time, Heather S. is a real person who works at Condé Nast and would actually probably be doing these stories. She's a content producer at Condé Nast. Her LinkedIn profile is out there. Do not bother this woman in any sort of way, obviously. But Maddox easily fits the first prong of criminal impersonation because she is definitely a real person, and there is no reason he would randomly pick Heather S. from Condé Nast and put that in his email if he wasn't trying to do that. Please don't have a heart attack. My heart is still good. My heart is still good. Criminal impersonation requires that a real person have been impersonated. Mr. Orangutan submitted an affidavit identifying himself as Heather. By all means, please advise who this Heather persona is in real life. Person, because Heather is not a persona. Heather would be a person. The real Heather would be a person, not a persona. And it's Heather S. You can do some research, you stupid thing. Guys, he's breaking my ability to insult him by being so dumb. You could do 5 seconds of research. Type in Heather S. Condé Nast and you'll find her on LinkedIn. This is not hard. Brett Anderson says, Heather S. isn't spelt correctly, nor is Condé Nast, nor is their address. All are fake. Landau has an airtight case. Yes. Again, when your defense is, I and my client are stupid and got it wrong, so clearly we're not committing a crime, that's not a good place to be. Oxygen Induced says, will this actually be worse for Maddox and Landau since it will actually highlight his lie and force a decision earlier than it would have been? I hope so. I hope so. Doug Romero says, everyone wants rackets defending them. Hashtag Flandwy. At Tess, does it matter? You're not supposed to do that, but you're my moderator, so I'm giving you a pass this one time. Does it matter that there are 2 Heather S's? I think I clarified this in the last one. I have only seen one Heather S. presently employed at Condé Nast. There is a different Heather S. who I believe used to work at Condé Nast Traveler, but I believe, according to her LinkedIn, she stopped working there in 2009. Someone is welcome to correct that if I am wrong. And drop it in a comment in the video if you want, or talk about it, that's fine. But in my research, this Heather S. has come out, is the primary one. If there are indeed 2, no, I don't think it matters because both of them are real people. Both of them are real people. And the question is not just, are they a real person, but basically, would impersonating this person induce someone to either provide a benefit to the impersonator or cause harm to themselves or another person due to that impersonation? And in this case, they absolutely were trying to get Asterios in trouble with his job, which is, it is within the statute. And I pulled up the New York court decisions on this statute, and in my opinion, they strongly support a conviction in this case. Nothing to say, but here's some money. Thanks, Dash X. And Pharaohzen says, Nikki Rackets, please play yourself in the inevitable movie of all of this. Gladly. 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 I can correct some mistakes that I may have made in earlier videos, if that ever happens. All right. Please advise. Do you really want them to advise who Heather is in real life? Guys, Munoz and Greenberger, if you see this, there's an open invitation. Just drop the LinkedIn profile on the judge's desk. I don't know what else you do. Just show Landau that he's a giant moron. Likewise, in this complaint, plaintiff pled, among other things, that Kokkinos and Weber-Shandwick were aware of what Kokkinos was doing. That plaintiff was among the people that contacted Weber-Shandwick to inform them of his conduct and actions, and that Kokkinos identified Heather prior to the complaint even being filed. And if I'm not mistaken, you dispute that. So, quoting his own complaint again, as he is wont to do, subsequently, defendant Kokkinos made a post on the Dick Show Reddit page where he acknowledged that Weber-Shandwick had knowledge of what he was doing and they had been contacted about it at least 3 times. Maddox could, of course, also apologize. People at Madcast Media have contacted one of my employers 3 different times now, trying to get me in trouble for my affiliation with a comedy show. He can apologize for that. Whatever you think that says, it does not say that, and bear with me for a minute, guys. Terry W says, is Landau from some parallel Earth without logic? Yes. Or no, I'm not going to give him that much credit. Landau is from this Earth with logic. He just fails to grasp it. He just fails to grasp it like he now has to fail to grasp a steering wheel. Barry Blatunic says, Santa Rackets. And H.S. Simmons says, Heather S. is a middle-aged Armenian doing the Buffalo Bill tuck. Yep. But okay, so bear with me on this, because this is important. So Landau's defense in this letter, and his defense, if I remember right, in his memorandum, is honestly that since Asterios accusing Maddox of being Heather, since he does that, then that puts the court on notice. That's how mentally handicapped this person is. And I don't mean that as like a slight towards people with disabilities, other than someone might mistakenly group Kevin Landau in with people with disabilities, and that is unfortunate for them. I mean that his brain cannot actually function in the proper way to conduct legal activity. And it's sad. It's very sad. But if you think that Asterios accusing Maddox of being Heather somehow puts the court on notice, you're not correct. You're not correct. And if you continue the misrepresentation in your complaint that you did, which must necessarily, the complaint must have post-dated the accusation because they include it in there. So you knew at the time you brought this to trial that Maddox was Heather. I know you did. You should be sanctioned. You're not going to get away with it like you did in Almasiga, you cuck. Defendant Kokkinos also indicated in this Reddit post that if plaintiff did not apologize to him, that he would exert ruthless revenge upon him, even referring to plaintiff directly. Or I can devote an effing month of my life to hiring artists, finding a publisher that will successfully chart on the New York Times bestseller list, writing a book called Classic Cucksmith Tales, and putting it out there for spite. Balls in your court, George. And I bet he wishes he did that, because it would have outsold the Alphabet of Manliness, probably because I would have bought boxes of it and just given it to homeless shelters and libraries, just to outdo Maddox. Ugh. Further in his complaint, plaintiff pled that upon receipt of the information, rather than the company taking internal action, it supported, or at the very least condoned, the defendant Kokkinos' behavior by informing its employee, who then doubled down on his crusade against the plaintiffs. Yes, for all we know, the most likely outcome is that Weber-Shandwick talked to Kokkinos and said, look, some weirdo online is claiming to be Heather S. from Condé Nast and is saying that you're doing these things. If they even named them, they may not have. I don't even remember if that's alleged in the documents that they named. Let's see. Kevin Flesher says an anagram for Kevin Landau Group is urinal puking tub. Thanks, buddy. My blood pressure needed that. And Jesse Samuel Anderson says, Fook K Ing. I don't know what that means, but I support your right to say it. I don't know that Weber actually mentions to Kokonos that Heather S. contacted them, where Heather S. claimed to be from. All we know is that Weber informed Kokonos that they were contacted, which, by the way, I'm sure just about put Asterios in the grave, because he probably thought at that moment, someone is causing me to get fired. And we know there's a sniveling little twat out there who's been trying to get Asterios fired. Well, more than one, I suppose, depending on how you take that definition. Okay. It is apparent that Weber Shandwick notified Defendant Kokonos of the complaint. Since after the General Counsel was made aware, Defendant Kokonos wasted little time in demanding an apology from the plaintiff, and then when it was not received, he increased the disgusting conduct illustrated herein. And just taking a stroll all the way back to video 1 or 2 or 3, wherever we covered this, that undermines your complaint against Weber, you stupid, illogical coward, because you're alleging that they didn't do their investigation and they didn't do the job that they needed to do, but them confronting Asterios shows that they obviously did and just disagreed with your disingenuous email. Just a moment. What your misrepresentations, conveniently fail to acknowledge is that in the subject plaintiff's complaint, Mr. Azunian did in fact identify himself as the person who made the complaints to Weber Shandwick. Plaintiff included said post within his complaints as follows. However, Weber Shandwick failed to take the requisite action or protect the plaintiff's privacy until such as an investigation was conducted. So now are you saying that you told Weber? Because here's what you're trying to do. Oxygen Dew says he increased exercising his First Amendment right. You're trying to tell the court now, without saying it, that Maddox disclosed that he was not Heather S. to Weber Shandwick, and now you're saying that Weber Shandwick lies. Man, I hope you catch fire. I mean, at this point, metaphorically speaking, you know, that your career goes down in flames where it belongs. Instead, Weber Shandwick effectively condoned Defendant Kokonos' conduct and immediately told him about the complaints, which you're saying on information and belief. You can't refer to your own complaint as things that are actually true, especially when you're talking about the internal workings of Weber Shandwick, you dummy. Whereupon Defendant Kokonos posted about it and promised to exact ruthless revenge against plaintiffs and retaliate for the complaint, which he did, making everything much worse for the plaintiffs. Good. Good. And you still have your wrong apostrophe. Recently, on October 24th, 2017, Defendant Kokonos sent a tweet indicating that he had been provided with said emails by Weber Shandwick. Okay, so they did say, yep, whatchamacallit, and that they had indicated to him that they were sent to Weber Shandwick by plaintiff Azunian posing as a reporter. That's not what he said. That is not what this post says. That is not it at all, you liar. It says, Chris, George pulled this same stuff on me. He pretended to be a reporter, emailed my employer, and tried to get me fired. That is Asterios putting together the obvious logical path to Maddox's poor life choice. That's all that is. The obvious thing, because no one named Heather S. cares at all about Asterios Kokonos. Sorry, buddy. No one cares enough to go write an article about his appearances on the Dick Show. It's not true, unless it's Maddox's friends, who Maddox has weaponized against Dick Masterson and company. Seriously, F asterisk 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 Landau. I agree, but I will not do that because that would be gross. Thank you, Raging Hot Truth, for that super chat. Accordingly, your desperate attempts and careless, potentially culpable accusations against this firm and the plaintiffs is noted. Okay. Is it noted in the letter that they sent to you, you idiot? Should you continue this pathetic display of lawyering, we will file a motion for contempt and sanctions. Accordingly, you have 24 hours to recant this nonsense. You are such a dirtbag because you filed a frivolous motion to gain an advantage, accusing Dick Masterson of defamation against you, you coward, when all he was doing was talking about your failure as a person, your obvious failure, which is public record in Michigan because you can't get behind a car without a fifth of liquor in your system. All he did was point to a true thing that is public about you, and you went and whined to the court about it. Did you send letters? Did you send a letter to Dick Masterson's attorneys? Did you? Maybe you did. I have to think that, you know, if it's common practice in New York to send a letter prior to filing a motion warning the other attorney, that maybe you did that as well. And you did this exact same thing. And now you're saying it's sanctionable? I hope you get sanctioned out of business. Alex Neves says, attempted court bamboozling a crime? It should be. In a sense, yeah. In a sense. Greenberger's response, and I am looking forward to this. I haven't even, you know, I haven't seen this, and Greenberger right now is one of my favorite lawyers in existence, and I can't wait to meet him at some point in the future. Dear Mr. Landau. Notice the class. He refers to him as Mr., even though he's obviously a man-child. Mr. Kokonos and I respectfully disagree with your March 13th letter and will not be complying with your demand to recant. In short, there was no concerted action. You misunderstand Rule 3.14 of the Rules of Professional Conduct. Shocker. Because we did not threaten to present criminal charges solely to obtain an advantage in a civil matter. See comment 5 there too. People versus Sadiq is not dispositive because that case concerned penal law. Okay, so People versus Sadiq is in the criminal impersonation statute. So it is not dispositive because that case concerned penal law 190.25 section 1 or subdivision 1. That is criminal impersonation in the first degree, which we and again, like, I'm not a New York lawyer. I am not a New York lawyer, and it took me 5 seconds to figure out that Maddox is probably not guilty of subdivision 1, which is criminal impersonation in the first degree. He's guilty of criminal impersonation in the second degree because he fits the description of the crime and the elements of the crime perfectly. And here, subdivision 2, which is the second degree of the statute, applies. Because Mr. Ozunian pretended to be a representative of a real organization, Condé Nast. Chris Carpenter says, how dumb is this dip S *** T? Very, very dumb. Very dumb. The bottom of the bell curve on the left side dumb. The Dr. Gnome says, so is the judge keeping this going for the lulz, or do they want to see if orangutan keeps burning money? The Dr. Gnome, no. There's actually the first hearing, and this is great. I'm going to try and find the court calendar on this as soon as possible. The first hearing on this will be Asterios' motion, and I believe it is on March 27th. That comes out in the memo up ahead, and I am going to try and get a calendar put together of the motion hearing dates so that we can maybe start to predict when some of these things will be heard. I was off on my dates because I didn't realize they were actually going to do hearings on this, and now seems like a good time to mention it. There is a Lawsplaining Reddit. There is now a Reddit, .com /r/Lawsplaining. It was put together by one of the Reddit Dick Show guys, and I really appreciate that he has done that. So go check it out and subscribe, and check the other areas where you can find me, and I will try and get a calendar put together for this stuff. Let's get back to this. So we just left off at Mr. Orangutan pretended to be a representative of a real organization. Condon asked, your ad hominem attacks on defendant's counsel is unwarranted and unproductive. True. And while Mr. Kokonos and Weber Shanwick may have suspected that your client was, quote, Heather, the issue is that your client repeatedly submitted sworn statements under oath that he was not Heather and then turned around and filed an affidavit stating that he was Heather. Since it appears that you do not intend to remediate this issue, and it is unclear whether you have even directly addressed this issue with your client in the short amount of time it took you to respond to my March 12th letter, then we intend to take the appropriate steps to notify the court and seek whatever relief is appropriate. This letter is without waiver of or prejudice to any of Mr. Kokonos' remedies or defenses, each and all of which he unlimitedly reserves. Sincerely, Jordan Greenberger, Esquire. Jamie Hughes says, wreck 'em rackets. Thanks, Jamie. Okay. On to the notice of motion. This is a short document which just lays out his ridiculous plans. Still hasn't fixed the apostrophe in plaintiffs. Yeah. Please take notice that upon the annexed affirmation of Kevin A. Landau, sworn to on the 14th day of March 2018, and I will not go through his annexed affirmation. There is nothing in there that I can find of use. Nice extra space, comma, space, and all exhibits annexed thereto, the accompanying memorandum of law and all pleadings and prior proceedings herein. Plaintiff will move at the New York County Supreme Court before Honorable Charles E. Ramos at the motions submissions part, room 130, 60 Center Street on the 2nd day of April at 9:30 p.m. Okay. And this is me this is me not knowing if that's real or an error, but I can't imagine a court being open at 9:30 p.m. to hear a motion. Maybe that's true, but I think he means a.m. or as soon. I can't know. He makes so many obvious mistakes that I don't know if that's a real thing or not. It would baffle my mind to see that. Or as soon thereafter as counsel may be heard for an order pursuant to 22 NYCRR 130-1.1a, granting their motion in its entirety and awarding sanctions against Greenberger, Munoz, and their respective law firms in the maximum amount of $10,000 and reasonable attorney's fees and costs in the amount of $7,500. Guys, this clown is saying that the reasonable attorney fee for this 3-page letter, 3.5, 3-page letter with a signature page, because his letterhead his watermark is so big, must be compensating for something, is $7,500. Because you can't ask for your attorney's fees for stuff unrelated to the frivolous activity. That doesn't count. I guess he's predicting that the motion hearing will require some more work or something, but $7,500? I'm torn. I'm torn between genuinely hoping that Maddox is paying this guy like $50,000 to $60,000 and not wanting to see a penny go into his pocket. It's like, I hope Maddox hands over the money and that Landau either drinks it immediately or lights it on fire, or it just gets teleported to somewhere else in some mastermind scheme. I don't know. Reply papers are to be served so as to be received by the undersigned at least 1 day prior to the return date on this cross motion. So on April 1st, on Easter, which I guess would have to be Friday. Maybe that's why they picked April 2nd, because with e-filing, they may file it on Easter. I don't know. But that would be April 1st. Raging Hot Truth, this guy's English and math skills are almost as bad as his driving. Yeah, so Maddox must drive like a samurai, but Landau drives like drunken boxing, I guess. All right. On to the Landau memo, and this is the longest document we have. So strap in. And I just want to point out that my YouTube app currently says we have 618 people watching a an attorney do his best impression of a child on a playground windmilling at his much bigger and much stronger opponent. I mean, oh my gosh. Cody Strader says, have you not seen the documentary Night Court? Touche, buddy. Touche. Corey Jamnick says, Maddox's plan all along, save his money situation by getting a lawyer so bad that he can turn around and sue him for damages. And I mean, at this point, oh my goodness. If Landau advised Maddox to lie, can you even, I can't even begin to think of what, oh man, Gats, I don't know if I can't pull that up on the stream very easily. Let me see if I can get that pulled up before we jump into this document. Barry Blatunik says, the ghost of the English is wrathful this year. It can't be simply confidential. And Adam D says, land we use as reasonable in reasonable attorney's fees, like the left persistently labels gun control reasonable. Yeah, shocking similarities. Let me see. Oh, man. All right, let me see if I can get this pulled up on stream real quick. This is the super chat from Gats. Hold on. Bear with me, guys, and we are going to jump into this document. Okay, come on. There it is. Can you see it? I can't. Hold on, I got to pull up OBS again. Oh my goodness. Thank you so much for that, Gats. It's simple, but it is poignant. Justin Brodak says Maddox and Landau are sofa king we Todd did. That's a weird string of words you have there, but we'll go with it. All right. How common are emails like this between attorneys? Emails between attorneys are very common. Try 505. Yeah, I mean, emails like this, I don't know. In my practice, they're not. I don't deal with people this incompetent. So I don't know, I don't have to worry about this. I deal with incompetent people, but this is a stretch of even that incompetence. So emails like this are not common at my firm. We will have little maybe jabs here and there, in passing, but usually it's in reference to actions of their client and things we might do about them. But I couldn't say how common it is in other jurisdictions or in other people's practices. I don't practice this way. I say what I'm going to do because typically, like, that's just the way you go about things. This is the law. This is what we believe the law says, and this is what we're going to do. And other than that, it doesn't make sense to do anything beyond that. I can't fathom this happening because it's so bad. Okay, on to the back to the Landau memo. So, statement of applicable facts. Currently, there are 4 separate motions to dismiss pending before this court that have all been fully and separately briefed by the parties. No, that is not true. They have not all been fully briefed by the parties because Weber Shandwick has not responded back to you yet, and they don't have to. So he has misrepresented the state of affairs, just the obvious state of affairs in this first line of the memo. Defendant Kokonos apostrophe, and write out 4. You write out the number 4. This is a professional document. You have a monosyllabic number. You actually write down anything up into a 3-digit number. You write down all single numbers. This is a lawyer court rule. Typically, not a rule, but just a writing guideline, a style guide. You write down a single number or a 2-digit number, and then once you get to the 3rd digit, that's when you start to just use the number itself. So, Anyway, defendant Kokonos apostrophe filed his motion to dismiss on January 6, 2018. Plaintiffs respond to this motion on February 5th, 2018. Defendant Kokonos reply to plaintiff's opposition, and there should be an apostrophe there, on February 13th, 2018. Okay, Jordan Greenberger, counsel for defendant Kokonos. Truly a champion of justice and a hero at this moment. Notwithstanding these pending motions, and having not raised any previous issue on the matter, on or about March 12th, 2018, counsel for defendant Kokonos, Jordan Greenberger, sent counsel. You know why he didn't raise the issue? Because your client didn't admit to perjury until the 8th or 9th. I can't even remember the date. Your client didn't admit to perjury. He didn't have cause. He didn't have cause to bring this up until your client committed a crime or admitted to the court of committing a crime. Counsel for defendant Kokonos, Jordan Greenberger, sent counsel to every party in this matter a letter expressly accusing plaintiffs of offering material evidence in this matter. No comma, that was false, and that counsel for plaintiffs violated Rule 3.3A3 of the Rules of Professional Conduct. Actually, he didn't say, actually, let me mansplain this to you. He didn't say you violated Rule 3.3A. He strongly suggested you consult Rule 3.3A and suggested that you fulfill your obligations so you don't violate the rule. He didn't accuse you of violating it, you whiny little sniveling, I don't know what, squirrel? I'm out of it. I'm out of insults. Of the rules of professional conduct. Further, in this letter, Mr. Greenberger accused Mr. Orangutan, one of the plaintiffs in this matter, of committing perjury, a crime, and accusing Mr. Orangutan of also committing the crime of criminal impersonation, New York Penal Laws, Section 190.25. That's because he did both of those things. And maybe something else too, maybe forgery, based on that email that he sent, which honestly could be construed as forgery under the law of New York. But, you know, alas, here we are. In this letter, Mr. Greenberger then claimed that counsel for plaintiffs was required to take remedial measures consisting of disclosure to the court. Yeah, that's Rule 3.3A that he was trying to help you not violate. Mr. Greenberger provided plaintiff with 5 days to disclose the foregoing issues with the court in light of the pending motions. Michael Munoz, counsel for Weber Shandwick, on or about January 10th, 2018. Defendant Weber Shandwick filed its motion to dismiss. Plaintiffs filed their response in opposition of defendant Weber Shandwick's motion to dismiss on March 8th, 2018. Defendant Weber Shandwick and plaintiffs entered into a stipulation extending defendant Weber Shandwick's time to reply until March 27th, 2018. Mind you, you said that we have been fully briefed. I'm glad you corrected that here. Notwithstanding the foregoing and having never raised any issue previously on the matter, counsel for defendant Weber Shandwick, Michael M. Munoz, submitted a letter on March 13th, 2018, which he sent to counsel for everyone joining in on Mr. Greenberger's accusations. And can you hear the whining, guys? He sent the letter to everyone, pointing out that I'm a dummy. In this letter, Mr. Munoz also accuses plaintiffs and their counsel of knowingly making misrepresentations in affidavits filed with the court. Why do you have a comma before filed with the court? And of continuing to, quote, mislead the court and the parties in sworn affidavits. That's because you did. Further, Mr. Munoz joined in on Mr. Greenberger's demand and threatened that if remedial actions were not taken, that Weber Shandwick would seek sanctions. You have a closed quote, but not an open quote. And that Weber Shandwick was, quote, evaluating our remedies for this deception above and beyond whatever corrective measures you take at this time. And the only time he gets his grammar and punctuation correctly is when he's quoting someone else's copy and paste. Good job. Therefore, Mr. Munoz implicitly threatened counsel. Oh my gosh. Nicholas King says, odds that Landau uses this motion as his notice to the court that Maddox lied. It's looking like it. It honestly is looking like it at this point. H.S. Simmons says, you know, scoff. I'm an attorney. Hey, that's my line, buddy. Therefore, Mr. Munoz implicitly threatened counsel for plaintiffs and the plaintiffs themselves that essentially if plaintiffs did not dismiss their case against Weber Shandwick, that they would pursue other remedies. Yeah. Yes, they kind of did that. Nick, did you see that Landau's letterhead symbol is literally a bottle opener? Someone else noticed it. No. Let me take a look. Oh my gosh. Ed Chambers says, rip in peace, Stephen Hawking, greatest mind of our generation. Oh, I mean, I don't know if that last bit is true, but he is a powerful physicist and a strong mind, and a person of very questionable character, if you go ahead and look into it. All right. And tomorrow my day's probably already ruined because the ghost of Stephen Hawking, no longer confined to his dreadnought, has been released and will haunt me and paralyze my limbs, like it did today. Okay. Evaluating our remedies for this deception above and beyond whatever corrective measures you take at this time. Therefore, Mr. Munoz implicit... Oh, wait. I went back. Sorry. Plaintiffs did not dismiss their case against Weber Shandwick that they would pursue other remedies, which could only consist of taking criminal action against plaintiffs and their counsel and or filing a grievance against counsel for plaintiffs. Is that what they said? That's not what they said at all, actually. So he's trying to attribute words to the Weber Shandwick attorney that did not occur. Gary M. says, rip in peace Maddox's career, lesser mind of our internet generation. That I can... I've got another orange drink because I ran out of orange juice. So this is I'm not sponsored by these guys. They're not getting ads on my free ads on my show. That was for Maddox's career. Responsive letter to Greenberger and Munoz. Let's see how he puffs up his own letter here. On or about March 13th, 2018, counsel for plaintiffs sent Mr. Munoz and Greenberger a responsive letter addressing their ridiculous correspondence from March 12th and 13th, respectively. Yeah, he gets respectively wrong here, too. Alexander Husky says, will the LoLsuit show up on George's background check when he has to apply for his old telemarketing job? No, but if they Google search Maddox, hopefully they'll see a list of my videos. In this letter, Mr. Landau explained that their contentions were disingenuous and approach unbecoming. Oh, further, Mr. Landau suggested that Mr. Munoz and Greenberger perform some badly needed research before making such accusations. You should perform some badly needed research before, I don't know, getting out of bed or continuing to live. Moreover, Mr. Landau stated as follows, the audacity you have of sending a letter like that to counsel for everyone. Why would you quote yourself in this? Like when your writing is so embarrassing. Threatening baseless criminal charges during an active civil litigation is outrageous, defamatory, and tantamount to an admission of unethical conduct by each of you individually and collectively. Further, Mr. notice, he explained this to them without any sort of citation or authority stating such. Further, Mr. Landau explained to Munoz and Greenberger that their letters and accusations of violating the criminal law and committing ethical violations were done, they're plural, were done for no, you say accusations, plural, were done for no other purpose than to gain an advantage in this case, given their client's extraordinary amount of liability, and that they were the ones that had violated the rules of professional conduct by sending a letter. And I mean, this doesn't matter, but they don't have hardly any liability. If any, I don't think at this point have any liability because all of your arguments are bad and all of your claims are hollow. Quoting himself again, it appears to have been concocted for no other purpose than to obtain an advantage, namely because of the extraordinary amount of liability your clients face. See Rule 3.4e of the New York Rules of Professional Conduct. Like, the amount of liability they face would have no implication in them of trying to obtain an advantage. Like, the extraordinary amount of $450 trillion has nothing to do with them trying to gain an advantage. Especially not under the rule here, which prohibits lawyers from threatening criminal charges solely to obtain an advantage in a civil matter. Notice it doesn't say namely because of the extraordinary amount of liability. Further, Mr. Landau explained to Munoz and Greenberger that they were simply incorrect about the criminal charges they claimed Mr. Orangutan purportedly violated, namely because a defendant cannot be convicted of criminal impersonation without proof that he assumed the identity of a real person, citing People versus Sadiq and People versus DeBranch. Again, there is a real person. Further, Mr. Landau fully refuted all of the nefarious accusations made by both Munoz and Greenberger in full. He fully did it in full, guys. First of all, that's redundant, you dope. You stupid, dumb dope. That's redundant. Second of all, you didn't fully refute anything. You didn't partially refute anything. Jesse Samuel Anderson says, could he know he messed up / trying to recover by being aggressive? Yeah, he's a cornered weasel. This is his only option at this point, but it doesn't excuse it. It doesn't excuse it. For instance, Mr. Azunian submitted an affidavit in response to Weber Shandwick's motion to dismiss, identifying himself as the Heather indicated in the complaint, and that this Heather persona was not a real person and had been identified as such in the complaint. Actually, it doesn't say that. It doesn't say that Heather was not a real person. He's lying in his own memo about what his other memo said, or what the affidavit said that he probably drafted. Stupid dumb dope is triple redundant. Mr. Landau fully explained that in his complaint, plaintiff pled, among other things, that Kokonos and Weber Shandwick were aware of what Kokonos was doing. The plaintiff was among the people that contacted Weber Shandwick to inform them of his conduct and actions, and that Kokonos identified Heather prior to the complaint being filed. No. It does not say that Weber Shandwick informed Kokonos that Maddox was the one who contacted them. It doesn't say that at all, because Weber Shandwick would have no idea who Maddox is unless Maddox sent an email prior or called someone prior to identify himself as the upcoming Heather S. emails. Or if he made another email to them later that said, I was the person who sent those, I was fearing retaliation, but you cucks told him who I was. Like, you would have to show this, and he would have it, right? He would have that email because he wrote it, but it didn't happen. You're lying about what happened still. And man, I hope at oral argument on this thing, they rip you apart. I'm not going to read his self-quotes again. Notice he has tab errors here, not to be confused with Trevor Burt. He has different tab errors in which he can't get his bullet points and indentation correct. Further, in his letter, Mr. Landau advised Greenberger and you included the letter. You included the letter. The judge can read it. You filed it. Advised Greenberger and Munoz that their misrepresentation in the letters conveniently failed to acknowledge. Never mind. That in the subject plaintiff's complaint, Mr. Orangutan did in fact identify himself as the person who made the complaints to Weber Shandwick, but you didn't do that. And that defendant Kokonos had even posted about it subsequently before plaintiff's complaint was even filed. That's not subsequent. That's not subsequent. You can't subsequently do something before something occurred. Accordingly, I'm not going to read his stupid quotes again. I think he's trying to form a bibliography. I think he's just incompetent. I'm not supposed to answer your question. Stop it. He's just incompetent at Microsoft Word. Ashton says MS Word is difficult, and so are breathalyzer tests. Yeah. He only failed him several times. He only registered alcohol in his breath several times. Accordingly, counsel for plaintiffs informed Munoz and Greenberger that accusations and threats were baseless and despicable. I'm glad he informed them of that, but he's simply incorrect. And that if they did not recant such nonsense, non-hyphen sense, nonsense is a word, Landau. Nonsense is one word. You don't need a hyphen. A motion for sanctions would be filed accordingly. So in saying that a threat is a sanctionable act, you proceed to threaten them. The logic is not strong with this one, guys. Greenberger, March 14th, 2018 letter. Instead of rectifying his misconduct or recanting or apologizing, Greenberger equivocated. He didn't equivocate. He did not equivocate. Go buy a dictionary, you dummy. You illiterate cuck. Go buy... I'm going to mail you one. I'm going to mail you one, and I'm going to highlight equivocated and put a bookmark in there. Have you heard of a bookmark? I'm going to put one in there for you so you can find it easily. He didn't equivocate. He did double down on his threat against you, but it's not a threat, an actionable legal threat. It's just basically an indication of what he's going to do. We call them colloquially threats. You can go look that up as well. Kendall and Hyde says Landau writes like a kid scribbling out a 4-page essay on the bus the day it's due. Absolutely. It's embarrassing. It's absolutely embarrassing. Jesse Samuel Anderson says, now I get how people spend so much on cam shows. I'm flattered. And doubled down on his threats against plaintiff and their counsel and claimed he did not threaten to present criminal charges solely to obtain an advantage in a civil matter. This is because it's not the sole reason to present criminal charges. It's to inform the police of a criminal act of your client and potentially you. Further, Greenberger continued to press his threats of criminal prosecution against Mr. Orangutan and stated that he was guilty of Penal Law 190.25 because he is. Further, Greenberger claimed that he intended to notify the court and seek whatever relief is appropriate. How dare he? How dare he seek whatever relief is appropriate from the court? Oh, man. Could you imagine if lawyers went to court seeking whatever relief is appropriate rather than $400 million like a bunch of nonsensical morons? Gary M says, will Landau have to blow into his checkbook before paying damages? Ouch. 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 Legal analysis. And this, I'm sure. Guys, remember, he's advising other people to do research. The imposition of sanctions, including costs and reasonable attorney's fees, is warranted for Munoz and Greenberger's contumacious, harassing, and frivolous conduct. Wow. He owns a thesaurus, at least. Section 130.1-1.1a of the Rules of the Chief Administrator provides in pertinent part that Tim says, random super chat to waste your time and completely distract you. Also, I need scissors. Scissoring is acceptable substitute. Hi, Tess. The court, in its discretion, may award to any party or attorney in any civil action or proceeding before the court costs in the form of reimbursement for actual expenses reasonably incurred and reasonable attorney's fees resulting from frivolous conduct as defined in this part. In addition to or in lieu of awarding costs, the court, in its discretion, may impose financial sanctions upon any party or attorney in a civil action or proceeding who engages in frivolous conduct. Landau. Buddy, I don't know if you want to bandy about the word frivolous conduct in this case. I'd be very cautious. Frivolous conduct is defined as conduct which, inter alia, among other things, is undertaken primarily to delay or prolong the resolution of the litigation or to harass or maliciously injure another, like maybe threatening sanctions and defamation and harassment lawsuits against someone for the actions of third parties in the midst of ongoing litigation, hoping to have the judge see that before your defective complaint because you can't draft a document with any sort of competency. In determining whether certain conduct is frivolous, the court shall consider 1, the circumstances under which the conduct took place, including the time available for investigating the legal or factual basis of the conduct. They gave you 5 days. They gave you 5 days to determine that saying you said a lie is an admission of perjury. That's it. That doesn't take much legal research. 2, whether or not the conduct was continued when its lack of legal or factual basis was apparent. Do you have any evidence of continuing whatever conduct has happened that literally happened yesterday and the day before and today? You can't even make the claim that it continued because it hasn't had an opportunity to do so. Should have been apparent or was brought to the attention of counsel of the party. You've been discussing it up until today before filing this motion. Gats. Landau forgot the filing, had a line where Maddox claimed he wasn't Heather, then convinced Maddox to confess, then got the emails and realized he'd done goof by convincing his client to commit perjury. Yeah, in all honesty, it sure looks like Landau is having nightmare flashbacks of Alma-Siga versus CIR, in which case he propagated falsehoods on the court. And I'll say it even if the court won't. He propagated that falsehood on the court, but narrowly avoided sanctions by somehow managing to shift the blame onto his client. He's trying to do it here as well because he knows what happens if those sanctions hit Maddox and him. And if he, out of his pocket, has to pay everybody's legal fees, he'll never drink again. Here the court finds that defense counsel's letter threatening criminal prosecution was, quote, undertaken primarily. Oh, okay, so, sorry, I skipped the citations here. In Jaller Color Graphics, Inc. versus Universal Advertising Systems, upheld on appeal, an identical issue was presented as the instant case. Here the court finds that defense counsel's letter threatening criminal prosecution was, quote, undertaken primarily to harass or maliciously injure. Notice he has a ... and who knows what is taken primarily to do what before the harass or maliciously injure. I didn't look up the case. I don't know. But we'll take him at his word. Plaintiff and plaintiff's counsel. They're not trying to harass or maliciously injure you. They sent you one letter informing you of their intentions and offering you an opportunity to recant. That's not harassment, and that's not maliciously injurious. You're the one bringing this to a judge before they've even had an opportunity. Jesse Samuel Anderson, will Landau throw Maddox under the bus? How? I don't know. Is he allowed near a bus? He might get on it and drive. That'd be even worse. The import and tenor of the letter, coupled with defense counsel's prior announcement that he was a, quote, former assistant district attorney. Guys, are you noticing the factual differences here for the state of New York? Unmistakably conveys the bold impressions that should plaintiff refuse or fail to abandon its already tried civil claims. Already tried civil claims. This is an identical issue. A former ADA threatening to potentially use his connections to bring criminal charges against someone for already tried civil claims. That's an identical issue here. Maybe you are so stupid. Defense counsel will wreak havoc upon his adversaries by commencing criminal prosecutions. And give that guy a medal. Because at least he threatened to wreak havoc upon his adversaries. I hope he screamed that in a loincloth. Impressions aside, the actual language used in the letter by Greenberger and Munoz, similar to the language and tenor. Similar to the language and tenor in Jalor, where they quote He-Man or Conan or Heracles. Similar to the language and tenor in Jalor Color, notified plaintiffs and plaintiffs' counsel in no uncertain terms that defense counsel was not only, quote, investigating plaintiffs' commission of certain specified extremely serious offenses. Yeah, we're going to investigate the possibility that your client committed extremely serious offenses is the exact same as I will wreak havoc upon my adversaries by commencing criminal prosecutions. But that Pony Cordero says Landau drives the bus every night when he clutched his toilet seat. Good joke. I'm sad I missed it. But that plaintiff and his counsel had actually committed criminal offenses, such as perjury as well as... okay. So the investigating plaintiff's commission of extremely serious offenses must have been... Okay, pardon me if I'm wrong. I think that he wrote this sentence so poorly that it doesn't make sense the way he thinks it does. This investigating commission of extremely serious offenses, which I had pause about because I don't remember reading that, an hour ago. But I was rolling with it because maybe it was in there and I've just forgotten. I'm pretty sure he's actually quoting the letter from Jalor Color. He's not even quoting this case, but listen to how he writes this sentence. Impressions aside, the actual language used in the letter by Greenberger and Munoz, similar to the language, comma, similar to the language and tenor in Jalor Color, comma. So that's a separate thought. What is that called? An appurtenance or something like that? If you're a grammar and you remember what a comma separated statement in the middle of a phrase is, throw it up in the chat and tag me, because I can never remember what it's called, but I think it starts with an APP, but I don't remember. Notified plaintiffs and plaintiffs' counsel in no uncertain terms that defense counsel was not only investigating. See, he wrote this as if Greenberger and Munoz said this, but I'm pretty sure he's quoting Jalor Color, because then he goes, but the plaintiff and his counsel had actually committed criminal offenses such as perjury as well as ethical violations. That's what Greenberger and Munoz's letters purportedly did, and that appropriate steps would be taken to notify the court and seek whatever relief is appropriate. His grammar is so bad that no judge on earth can understand that sentence without reading it 2 to 4 times. A positive. Thank you, Andrew Gluck. Gats says, cut him some slack, man. He was drunk. Hi, Haley. A positive. A positive is close to apostrophe, and that's probably why he can't do it. Therefore, Greenberger and Munoz's threats and accusations were clear. If plaintiff Zunian did not dismiss his lawsuit against them or inform the court that he committed perjury and his counsel committed ethical violations, that's not what they told you to do. They didn't tell you to say you committed ethical violations. They're trying to save you from the ethical violations, you dummy. Then criminal, then, it's an E, it's an E, it's an E, it's an E, it's an E. If then, E, criminal prosecution would be pursued against him. And Munoz, you don't do a semicolon and. You don't do a semicolon and. Munoz and Greenberger would file a grievance or take other actions such as filing criminal charges against Mr. Landau, Mr. Azunian's counsel. I don't think they threatened criminal charges against you, although they should. Your very existence as a lawyer is a crime in some way. And if the letter, but it's not your fault. It's probably the New York State Bar's fault at this point. And if the letter itself left any doubt about its threatening and coercive nature, the annexed copies of the penal law highlighted by counsel for emphasis effectively laid that doubt to rest. Defense counsel, having failed to put forth any defense at trial, was attempting to accomplish by harassing threats what he was unable to accomplish at the trial itself, namely dismissal of plaintiff's breach of contract claims, and he's quoting Jalor Color. Again, notice this is someone threatening to do something, threatening to get someone to drop their already litigated claims. This is identical to Munoz and Greenberger's threats and letters in this instant case. No, it's distinctly and obviously different to anyone with half of a mind. If Greenberger's letters left any doubt about its threatening and coercive nature, the annexed copies of the penal law and ethical code highlighted by counsels for emphasis, stating that Azunian had in fact committed such crimes and Mr. Landau had violated the rules of professional conduct, effectively laid that doubt to rest. Good. You should have no doubt that Azunian had in fact committed such crimes. You know he did because you probably advised him to do it. Both Greenberger and Munoz, having failed to put forth a defense in their motions to dismiss, were plainly attempting to accomplish by harassing threats what they'd be unable to accomplish, namely the dismissal of plaintiff's claims against them. Oh, that's a bold statement. As in Jalor Color, yes, pre-trial litigative motions are the same as post-trial actions. God, you're so stupid. The threat was undertaken primarily to harass plaintiff into abandoning its claim and to otherwise maliciously injure plaintiff, or is clear from the critical, precipitous timing of the letter and the context in which it was sent. Avier Miedo, thanks for the donation. Counsel's threat was not an off-the-cuff remark made in the heat of battle without time for adequate reflection. Instead, the threat, which was never retracted, not even in hindsight, was made only days after the trial had ended and during a time when a verdict was pending. Trial had ended. It's identical, though, right? Right? What? have you guys read Slaughterhouse-5? I mean, maybe Landau is one of those beings that sees all time at the same time. One of the aliens. Maybe that's it. It's the only thing I can think of. So maybe he sees Maddox back when Maddox was with Funny. Guys, I think I've solved this. Landau is an alien from Slaughterhouse-5. He sees Maddox when Maddox was Funny, and he sees this motion in the future after trial. Further, the threatening letter must be considered in light of the prior letter written by defense counsel in which he explicitly stated that any further fraudulent demands for monies will be considered and treated as fraudulent and or extortion and will be promptly prosecuted. Again, that's quoting Jalor Color. I thought those beings were already dead. Tralfamadorians. That's the name of those beings. Good job. Here, the hearing on Kokonos' motion to dismiss is scheduled for March 27th, 2018. Man, I wish I could be in New York on March 27th, 2018. The very same day that Weber-Shandwick's reply is due, the threats made by Munoz and Greenberger were undertaken entirely to harass plaintiffs into abandoning its claims and otherwise maliciously injury plaintiffs. Injure. You put an E, not a Y there. And their counsel. It is clear from the critical and precipitous timing of the letters. What critical and precipitous timing? You're 2 weeks. You're 12 days. 12 days before Weber-Shandwick has even responded, and you're 12 days before Asterios' hearing. And in the context in which they were sent. Greenberger and Munoz's threats were not an off-the-cuff remark made in the heat of battle. You're trying really hard to attach this, but it doesn't work. Without the time for adequate reflection. Instead, they were made months after motions to dismiss have been filed. Not months. Not months, pal. 1 month. And opposed. Certainly not months after they'd been opposed. They were opposed, like 2 weeks ago. Less than 2 weeks before the hearing on Kokonos' motion to dismiss. Good job not having an apostrophe in one place where you should have it, you dummy. Avier Miedo says, Rekieta Law, do you think Landau has seen more grammar police or more police for DUI? I think he's probably seen more grammar police, but unfortunately, they just don't have the same tools. Because if only he could be kept away from all paper products in the interest of preserving the sanctity of the English language, we would all be better off. Under these circumstances, the threatening and harassing letters of defense counsel were part of a calculated, deliberate strategy designed to harass plaintiffs into folding its litigation hand lest the wrath. Who's he quoting? He must be quoting Jalor Color with that line of Munoz and Greenberger and their respective law firms would be unleashed. And plaintiffs would be prosecuted. Landau, in case you don't know how procedure works in New York, Greenberger and Munoz can't bring criminal charges against you. They would have to bring them to a criminal prosecutor in the city of New York, or in whatever district you're in, and the prosecutor would have to review the evidence and decide whether or not to bring charges. The other guy in Jalor Color was a former prosecutor, allegedly, who would then, by implication, be able to get one of his colleagues to file those criminal charges against you, or against them. You should be prosecuted anyway. Eddie Jefferson says, rackets, are you, oh, buddy, I'm not going to answer a question like that. I very much respect my wife, and I'm all for fun and games, but, I get it, but we don't, yeah, that's not respectful. Sorry. Still love you, buddy, but, I'm a husband. The conduct of defense counsel Greenberger and Munoz crosses a line and cannot be tolerated by the court. Although the court is not required to make any findings as to whether defense counsel violated any of the pertinent disciplinary rules, or whether defense counsel should be otherwise disciplined, it is noteworthy that the Code of Professional Responsibility Rule 7-105A provides that a lawyer shall not participate in presenting, or threaten to present criminal charges solely to obtain an advantage in a civil matter. It's not solely. It's not solely there. Applying the foregoing rule, courts have not hesitated to discipline an attorney who has threatened criminal action against his or her adversary in a civil matter, see, e.g., matter of Glavin. Attorney's letter sent on behalf of client which suggests that attorney possesses authority to impose or withhold criminal sanctions and threatens the use of criminal process to coerce the adjustment of a private civil claim violates the disciplinary rules and warrants censure. Again, not even close to comparable. Not even close to comparable. Not at all. In RE Beach Board, censure warranted where attorney sent his adversary a letter containing threat that unless small amount of money was immediately paid, attorney would present matter to district attorney on charge of larceny and embezzlement. Yeah, that kind of sounds like extortion. And again, not even close to the present situation. In RE Hyman, censure warranted where attorney sent adversary a letter stating that, quote, unless you show some substantial evidence of your willingness to compensate plaintiff for her injuries, I shall have no other alternative but to immediately criminally prosecute you for assault. See also Joel Cohen and Sarah Diane McShay threatening to contact the criminal authorities, a lawyer's dilemma. Citing cases. Good job. Significantly, counsel for plaintiff attempted to avoid the imposition of sanctions and filing the instant motion and gave defense counsel a reasonable opportunity to be heard and recant his previous threats. No, he gave you 5 days. You gave him no days. So how do you even think this is comparable? And yet, for reasons unknown to plaintiffs and the court, defense counsel has decided to double down. Maybe because he's right and you're wrong. And you know you're wrong because your stupid sanction motions get shot down left and right in your other cases. By the way, we will be having a special video at some point in the future, as soon as I can research it, on how to lose a motion to bring sanctions against your opponents, starring the documents of Kevin Landau. And continue to threaten criminal prosecution. They're not threatening criminal prosecution. They're threatening to bring the criminal activity to the attention of prosecutors, and prosecutors will make that stuff. Will make that determination. And frankly, I don't know if they even need to at this point, because I'm sure there's a ton of people willing to notify the New York prosecutors of your client's actions. But the one who definitely could is Asterios Kokkinos, as he's the wronged party. He's the wronged party by your client's second-degree impersonation thing. He could actually legitimately file a police report, I believe, unless I misunderstand the New York police process. He could file a police report against your client, and then they could investigate it, or they could send it to a county attorney. That would be up to them. Defense counsel, ethical violations and other contumacious conduct if plaintiffs refuse to dismiss their complaint or confess to perjury. This court, mindful of its overriding responsibility to deter conduct that inhibits the proper administration of the court system, like filing a frivolous motion to try and suppress the free speech of the entire world, you stupid cuck. Oh. Ugh. I don't wish ill upon people. I don't wish ill upon people. Serenity now. Serenity now. Cannot countenance defense counsel's conduct. Sanctions must be imposed. That's great. Accordingly, plaintiffs respectfully... Why do you have an apostrophe there? Plaintiffs respectfully request that their motion for an order imposing sanctions upon defense counsel Munoz and Greenberger and their respective law firms be granted. In Jalor Color, the First Department appellate term held that the court was not required to hold a formal evidentiary hearing before finding defense counsel's conduct frivolous and imposing sanctions for making threats of criminal prosecution during the course of the underlying civil lawsuit as part of a calculated, deliberate strategy designed to harass plaintiff into folding its litigation hand. If I'm correct, and I'll go back through the documents when I'm all done with this part, back during the Q&A and look for this, I don't think they actually asked you to dismiss your claim. I think they suggested, per the ethical rules, that you inform the court, not dismiss your own claim. I don't think they want you to dismiss your own claim right now because I think they're looking for lawyers' fees from you and your client. Think about that. Or don't. Actually, don't think about that because if you think about it, you'll come to the wrong conclusion because your brain's broke. upon his frivolous and vexatious litigation practices. Oh, okay. So did not abuse its discretion in directing defense counsel to pay sanctions of $7,500 to the lawyer's fund for client protection and attorney's fees of $2,100 to plaintiff's counsel based on his frivolous and vexatious litigation practices, threats of criminal prosecution made by defense counsel during the course of the underlying civil lawsuit were part of a calculated, deliberate strategy designed to harass plaintiffs into folding its litigation hands. Mulker3 says the infrequently used Oxford apostrophes. Conclusion, relief requested. Wherefore, plaintiffs respectfully requests. Let me help you, Kevin. Plaintiffs respectfully request. There's no S on requests when you have a plural subject. That the court grant their motion in its entirety and award sanctions against Greenberger, Munoz, and respective law firms in the maximum amount of $10,000 and reasonable attorney's fees and costs in the amount of $7,500. JJ Death says Landau doing good only as an example of how to F up. Andy Polo says, I feel like Hemingway reading Faulkner. Oh, brutal. Chap 666 says Landau is the Maddox of attorneys. Okay, guys. That's the documents. That's it. That's it. It's embarrassing. It's disgusting. This guy needs to be stopped before he hurts more people. And if you don't think he hurts more people or he hurts people, this guy charges a fortune. Mind you, just for the defense of the letter sent by Greenberger, he's alleging $7,500 in fees just for the letter. This guy is a menace to clients, and it's sad that they are probably not able to recover based on his disgusting actions, and he is an embarrassment to attorneys everywhere. H.S. Simmons says Landau is like an ironic, surreal meme attorney. Yeah, it's crazy. Like Landau is like India. I'm pretty sure neither of them actually exist. 4chan created Landau to meme. They duped me into memeing a fictitious attorney. Whatever 3241 says, oh goodness, that was a doozy. Okay. All right, guys. Neil Purcell asks a pertinent question. Let me share a secret with you guys. It's not a secret at all, but I'll call it a secret. He asks, when you get angry, do you become the Incredible Wrecked? In a way, I'm actually allergic to being warm, and that can be triggered by rage. So that's a real thing. It is very frustrating. It's called collagenic urticaria. Look it up, and someone get Shkreli to research a cure for it in prison. That would be wonderful. I would love to get back to marathoning again. Gatscat says, what odds you give me if I bet Landau wins anything? It would be unethical for me to make odds on that. Yes. And, okay. So what's going on now is we're done with the documents. So at this point, if you were just in it for the hot take infos, the 1 hour and 40 minutes of hot take infos, on the documents, you can stop now if you do not like the open Q&A, format, but I'm going to move towards a more open Q&A. I still love the super chats that come in, but I will attempt to address the regular chats as they occur, and you tag me. If you have questions about any specific spot in the document and you didn't get to ask because you didn't super chat before, now is a good time to ask them. Jesse Samuel Anderson asks, memories of when you were just an angry Facebook fan. No kidding. No kidding. All right, so let's see. Andrew asked, how did court go this morning? It was this afternoon, and we didn't even have to appear on the record. It was just a waste of everyone's time. That could be solved by courts adopting something called email, which is a brand new invention. So we'll see. Eric Blum says, do a quick recap for those who only just came in. Okay, yeah. Greenberger sent a letter to Landau stating that Landau's an idiot and Maddox commit perjury. Munoz, who is the attorney for Weber Shandwick, agreed with that and sent a letter as well. Landau cried and sent a letter back to Munoz and Greenberger. Then Greenberger responded and said, no, you idiot. We're gonna stick with what we said. And then Landau, of course, now runs to mom and attempts to get sanctions. Because if you haven't noticed what Landau's strategy is, his attempt He's trying to poison the well by poisoning the judge's opinion of the defendants before the judge gets to looking at anything on the merits. That's his goal in all of this. That was his goal in the motion against Dick Masterson. That's his goal. He's trying to poison the judge's opinion of the parties here. And that's what you missed. Go back and rewatch it. Do we actually know if Simon & Schuster owns the Maddox brand, as much earlier documents implied? Did anyone confirm it one way or the other? We don't know. I don't know how we would actually find that out. But yeah, so we're into addressing the chat here. Spicy Tony says, what's up, my man? Gigawarp does a super chat. You should stream Ace Attorney. I've gotten that a lot. I need to figure out how to do that. So are Greenberger and Munoz bemused or enraged? I would think enraged. With a little bemusement sprinkled in for spice, like the spicy meme guy, right? Dropping it on the elbow. Gabraham Sandwich says, why did in the initial letters did the lawyer say it was unclear what other remedies Landau could do except disclose to the court? Because what he's saying is what you did or what your client did is so egregious to the claim, like by lying, we don't know how you can remedy it other than saying my client lied, like specifically informing the court that the client lied. Other than that, there isn't a remedy. There isn't something that they can do to correct the wrong other than simply saying they lied. Maybe there's something out there, but they just don't know what it is. Let's see. I'm embarrassed. Please redact this live stream in 24 hours. Sanction me, buddy. Fish Monster says this was a nice format for live streams. Are you going to do a video on the New England Clam Company versus my garage? Yeah, we'll do that. RoboCop or Judge Dredd? The old RoboCop is better than Stallone Dredd. The new Dredd is better than the new RoboCop. How's that? Is there a strategy behind presenting the option to Landau to report to the court? Why not just do it themselves? Because, yeah, the strategy is, look, you come clean with it, or we're going to. And they actually gave him an opportunity to do so. They could have filed the motion immediately, requesting sanctions and demanding Landau to do it. The only other strategy I can think of is they're hoping Landau will say something that puts him in the culpability chamber with George. That's what it is. See, when, if ever, in this matter, should defense counsel bring up the clean hands doctrine of equity for plaintiffs and their counsel? There's no real contractual case here, and clean hands tends to be an equitable matter in contract claims. So clean hands probably doesn't apply in this case. Should the government force a Christian baker to bake a cake in violation of his religious beliefs? I don't think the government should force anyone to do anything in regards to their business. I don't know that it's wise for a Christian baker to refuse to bake a cake for anyone. That's not the point. I just don't think the government should have any say in it. And if the people want to eat the consequences of not baking cakes for certain groups of people, I think today we have enough social media to go ahead and shut down whoever or let people know about whatever. And it's also easy enough to start a business today that you can make a competing cake shop if you really want to service other people. So that's my opinion. Do you think Maddox might actually have a shot at being better at lawyering than Landau? Maybe. Alex Neve says, does experience count for a lot in lawyering? Hasn't Landau been a lawyer for a decade? What in the world? Thanks for the great hot takes, Nick Rocket. Experience only counts if you learn from bad experience. Like that's the whole point. If you're screwing up constantly and losing, but still making money and people still hire you, why change? Why change? Echo Black asks if Maddox still thinks he's got a shot here. Yep, I think he does. I really think he does. Because Maddox doesn't understand how anything works. I mean, he doesn't understand how anything works. And that's evident if just go back and listen to some of the Biggest Problems episodes, you'll see it. It's plain as day if you just divorce yourself from the idea that he's a comedian and realize that people thought, like, we've all been making fun of the disabled this entire time because we thought Maddox was joking, but Maddox was just telling people what he really believed. Are the hearings billed as trial time? Did this lawsuit just get a lot more expensive? Yes. Yes. Since Maddox purportedly sent the Heather emails from California, can he be on the hook for criminal impersonation in both states? Can 2 states try a party for one single act? Probably not. I think since the email was sent to a New York party and the harm would have occurred in New York, he's likely under the New York law. But, you know, whether California could exercise jurisdiction over that act, I think is a better question for someone like Keon. And you should maybe tweet to him and see what he says. Ready to cuss yet, bruh? Nah, I mean, I think I made it through. Trying to keep these family friendly, guys. It's difficult. Fispams says, I'm adding into the please keep this plow through format for future videos requests in concert with Fish Monster, Johnny Olson, and Tess. Yeah, it's a new thing. I've gotten a couple complaints about the other, the wide open format with too much chat interaction, making it difficult to watch or listen later. And I get it. Like I said, I'm in the business of making a product for people and I want it to be, readily consumable. Here you go, Gary M. I'll help you out. In your legal opinion, is Madoff a bitch? Yes. Madoff, you's a bitch. How badly is Weber Shandwick going to crush Landcuck? I mean, I cannot wait. I'm actually excited for a legal document to drop in a case that I have nothing to do with, and that makes me really happy. Is it actually illegal to tweet strobe images to Kurt Eichenwald? I don't know, but maybe. Maybe if that, I assume he has some sort of epilepsy that would potentially cause him harm. How long until this case gets dismissed? Well, it turns out the first hearing is March 27th, and that's Kokonos's motion hearing, and we'll see what happens then. I don't know if the court will rule from the bench. They've had a long time to read the documents, so they may issue a ruling there in court. They may allow some oral argument to see if it will change their mind, but I'm guessing the judge will have his mind made up on that motion to dismiss by the time they get into court. Whether or not he issues the order that day, I just don't know. Through the fly or over the band? Through the fly in a suit, over the band in jeans or sweats or workout pants. Rekieta Law, I love the docs and I want to stay, but work starts in 6.5 hours. I'll watch the rest tomorrow. Thanks for the show. Get out of here, buddy. Don't read work for this. Do you read SCP? Help me out with SCP, Kenster. Because the acronym's failing me right now. I spent the last 20 minutes of my life trying to download Everybody Wants to Be Poppy legally. How do I get that without breaking the law? Also drink for super chat. I don't know, buddy. Good luck. To your knowledge, has Landau ever won a case? No. From what I've read, I have not seen him win a case. But I have not looked into his case history in Michigan at all, so I can't comment on if he has won a case in Michigan. The cases that are available on the New York search are either ongoing or he has lost them or they have settled out of court. So, you know, maybe he has. I don't want to state for sure that he has not. I just don't know. What's your favorite hot dish? And also, what is your favorite lake in Minnesota? I'm not a big fan of lakes, but my favorite one would be George Lake for various reasons. You know, and then what is my favorite hot dish? I'm not a fan of hot dish. I'm a transplant to Minnesota. I'm from Texas. I don't like everything mixed together in one sort of thing. I like my meals separated out. Emacs or Vim? I have no idea. Sorry, Prima Fascist. I don't know the answer to that question. What's your favorite cheap beer and favorite super hip fancy beer? I don't drink beer. I haven't found one that I like yet. Open to finding one, but I couldn't tell you. Is Maddox, in your opinion, actually a cuck? You know, I think he might be. Old RoboCop versus New Dredd. Man, I can't. They're almost too different to determine. Old RoboCop is such a Verhoeven masterpiece, and New Dredd is like the American version of The Raid. I loved it. So if I mix Balmore and Fireball, have I committed a crime? Yes. Export yourself. Let's see. How far back am I? Okay. Ballpark, how much do you think all the defendants have spent on lawyer fees? I think right now they're approaching, spent is a weird word, because Patreon, I think, is using in-house counsel. Weber isn't using in-house counsel, but I think fees in this case for the defense come out to, at this point, probably close to $100,000. If I had to guess. I'm in New York City. Should I look into sitting in on this? Absolutely, man. Where better than to see it live? You can probably do it as long as you're not unruly and you don't actually like attempt to record the proceedings without permission. See if you can get a press pass and record the proceedings. That'd be the real win. I'll make you an official member of the Rekieta News Network and offer you press credentials if that would work. If you genuinely want to look into it, I will do it. And I think we can get Mad Cucks on board with the Rekieta News Network issuing press credentials for Eric Blum. So let me know. Is Landau going to be able to force Shandwick to pull in the real Heather S. to prove her existence, or will they be able to leave her alone? I think they'll be able to leave her alone in this. I think merely bringing up her LinkedIn profile puts it out there that their claim is reasonable enough. Will Landwee's dad have to come in at some point to try and bail his son out again, like in his DUI case? It may be better for him. It may be better for him. Yeah, it's like a tag team. Have you read Maddox's latest article published a couple days ago? I say don't because it's unfunny and lazy, but I feel it shows how much edge he's lost and how depressed he must be. I don't know what you're talking about, fam, but keep it lit, keep it 100, and keep it trill. Do you think I can convince Landau to sue an actual dog for the right price? Yeah, probably. Let's see. Have you checked out a webcomic called The Illustrated Guide to Law? If so, thoughts? I don't know what a webcomic is. I'll have to consult the expert, Ben Honeycutt, for that. SCP is a catalog of creepypastas written like the secret files of a government organization. No, I don't read that, but I would, because that sounds great. The Raid or Dread? The Raid barely edges it out just because the knife play in the Raid is so brutal. But the Raid 2, as much as I love it, is weird for bringing Mad Dog back in the way it did. So I don't understand that at all. Try some stouts. They're the liquor drinkers beer. I will, buddy. If you want to, oh yeah. Tag me so I can see your question. If Landweed loses his lawyer's license, do you think he'll get a podcast on the Madcast Media Network? Yeah, I mean, why not, right? He can do a legal podcast and compete with me. That'd be great. Tess sent me a bunch of butt nudes, but I wanted chest nudes. How should I sue? You should sue in the proper jurisdiction. Whoa. New York does not allow recording, only those court drawings. Oh, that's too bad. It's too bad. If Heather S. is a producer herself and not the actual reporter, will that matter? Also, what about him claiming freelancer employment at Condé Nast? I don't think that will matter because Heather S. I think is a content creator. And I don't think he has to be, I think if Heather S. wanted to write, and I'm just guessing, but if she wanted to write an article for Condé Nast, then that's probably something she could do. I don't think that would matter. And him claiming freelancer employment at Condé Nast would be weird. I'm not impersonating this Heather S. I'm impersonating a different one that I made up. Nick, do you recall how many New York cases you looked at where Landweed has lost? They don't, the records only go back so far. And many of them are ongoing, but I think he has lost 3 or 4 that I've read out of probably 7 to 8. Don't quote me on those numbers because I haven't looked at them in a couple weeks, but that's where it's at. And I'm hoping to do some reviews of those cases. Is Mad Cucks complete in the clear now? You're never complete in the clear, but he's about as in the clear as you can be. I mean, in theory, they could serve him and try and come up with some ridiculous argument as to why it's valid. But I think it'd be laughed out of court. I have press credentials in New Jersey. Would that be good enough to get me in with an audio recorder? I don't know. I don't know the rules. You could probably call the court and ask. Say, can I sit in on this thing? I'm a member of the press. We're very interested in this. Can I record it? So you could just ask that. Isn't it great that Maddox sounds like such an old internet grandpa that he made saying "my dude" that much more humorous? I love it. I love it. He's honestly get off my lawning the internet that has moved so far and fast past him that he's losing subs faster. I'm going to use my old joke, faster than Germany in 1918. If you actually played Warhammer 40K, what faction would you run? Man, right now I would probably run Adeptus Custodes because they're just cool. I've always liked Custodians, and I'm curious how their army works. Mad Dog was a different character in the raid too. They used the same actor, which made it confusing. Yeah, I don't think they made a very good job delineating between the two characters. I got the impression that he was the same guy. So yeah, but I'll take your word for it. But yeah, and I liked the Raid 2 a lot. It's still awesome. I would put Dread above the Raid 2, but I would put the Raid above Dread, mainly because when I saw the Raid, I was just stunned that that movie was made. It was very, very cool. Javier Miedo says, can Maddox claim to be going under the pen name of Heather S. in regards to this case to get out of it? I mean, he can claim a lot of stuff. And here's an important thing I mentioned in the other stream. I don't know if my dude Maddox will actually be prosecuted. And there's a big difference between committing a crime and even fulfilling all the elements and prosecuting something successfully. Christian Scott Relev says, get me in New York. I'll draw the court sketches. That would be great. There's a big difference between having charges brought, winning the charges, and simply being guilty of a crime. Lots of people, probably most of us, are guilty of some sort of crime, but getting convicted of it is a little bit tougher. You know, unless you have seen weed, then you can get convicted for anything. If you've seen marijuana in your life, good luck. Maddox Law says, should the court determine if Maddox is the biggest chump in the universe? All this effort, time, money over hurt feelings. Unbelievable. Absolutely, they should do that. Ever try smoked beer? No, but I am intrigued. In your legal opinion, is it normal to have an average size right nut and a grapefruit size left nut? I'd get that looked at, buddy. You've seen 2 marijuanas at the same time. Are you currently in prison? Mr. Nope 100 says, if Maddox gets a sex change and changes his name to Heather S., could he avoid a perjury charge? I hope. Like, guys, if he takes if he takes the Spacey defense to the full 100 and does that, he almost deserves to get out of it. With all the stream activity going on this week, are you still up for streaming Friday if more docs aren't dropped? I am. I don't know what we'll do yet, but I want to make a Friday stream a regular part of the channel. And so I will be attempting with all diligence to find something. And on Friday, I'm going out for a very nice meal with Lady Rackets before any stream time. So I will probably be in a pretty good mood. Why in the letters do they say they reserve all rights, etc.? Isn't that implied? It is implied, but it's just some boilerplate that you throw in there to make sure you're not saying that by, what they're saying is, you know, because they're asking them to go ahead and, they're asking Landau to go ahead and tell the court and saying, you know, if you just go ahead and tell the court, we're not going to motion for sanctions is basically what they're saying. But they're also reserving the right to motion for sanctions anyway. And that's important because they're not giving up their ability. They're not making some deal here that is a legally binding contract. So they're just making sure that everybody knows that they still have the right to do this. Have you tried vaping scotch? I have not tried vaping anything. Since you are and somewhat of a libertarian, do you think we should just legalize all drugs, not just marijuana? I'm remiss to jump there now. I think ultimately that's a goal, a long-term goal. I think like the libertarian agenda should almost always be a far off dream because I don't think it's practical to move from whatever level of tyranny we have now to just open freedom because I think it will cause the deaths of tens of millions of people who won't be capable of being on their own. But I think keeping that as a far off dream is certainly something that we can work towards and maybe society will somewhere get there. I think a lot of drugs do need to come off the block. Marijuana is the first and most obvious step just due to the fact that we have much worse stuff for us in sandwiches these days. You're now manually breathing and blinking. Sorry. Are you going to butter up Lady Rackets for some favorable duo stream appearances? Yeah, if Lady Rackets is watching and is interested in popping on the stream to say hi, I'm sure it would be appreciated. She was watching earlier. I don't know if she's still up or not. Boot socks and cargo shorts or Tavis and socks? Boot socks and cargo shorts. Tavis and socks, man, that's ugly. Isn't libertarian drug use in the Ark of the Covenant? Yeah, I think so. The Raid versus the Protector. I gotta go with the Raid, but I love the Protector. Man, that like limb breaking clinic that he puts on is like my favorite scene. Have you ever considered running for public office? I have considered it, but man, I've worked on a political campaign. And I have a friend who's a politician, and it is a nightmare. And it's doubly a nightmare if you have a family. So in the interest of keeping my family sane and not hating me, I don't think that that's in my thing. Right now, I'm more interested in building a public voice on platforms like YouTube. If people want to hear it, I think that there's room for entertainment to change the world in ways that politicians never will. Crosswords should come before marijuana. What is your celebratory ritual after a case has been resolved in your favor? Man, I don't have a ritual for it, but it is seriously bordering on the best feeling in the world. It really is.
What is it?
Winning a case. Winning a case. Hey, Lady Rackets is on stream, so they can hear you. So if you talk.
Hi.
Let's see. You see that OJ confession interview that came out the other day? No, I haven't watched it yet, but I will try and give it a look because someone mentioned it yesterday in the other stream that I didn't plan on doing. Have you ever considered running for D's nuts? No. The Raid versus Shrek 3, the Raid wins. Chap666 says Bloodsport is the only movie worth watching. And there's a good case to be made for Bloodsport being the only movie worth watching. Even though Frank Dukes largely is a chump and the story is mostly fictitious, it's a fun one anyway. How hard do you think the defendant attorneys are going to go after Landau now that he's tried to dick punch everyone? I think I already thought Weber was going to go full bore, but now, I mean, I expect it will be face melting. Whatever a face melting legal document looks like. Does Lady Rackets have fertile sisters? I mean, I guess, but they're married.
They are both married.
He's fleeing could Lady Rackets please say he's fleeing the interview?
I don't know why you have to keep saying that.
I don't know.
He's fleeing the interview.
Favorite Disney film of mine? What is my favorite Disney film? And I assume you mean Disney animated film. I don't want to cop out and do like a non-animated film. Gonna go with Lion King. If I like stealing things now and then for cheap thrills, what's the worst that will happen if I get caught with something small like a really nice lipstick? You got to ask Winona Ryder. It's not good. Shoplifting is prosecuted pretty harshly in most places. Any stories about how you got food poisoning from eating Lady Rackets chili and totally not related to consuming bad pickles? Nope.
Nick does all the cooking.
I do. I cook.
Maybe not all, but most.
I cook the vast majority of meals. Can I have some orange juice? Yeah. You have permission. If Landau were to be disbarred, how might that happen? So Landau being disbarred would involve first sanctions from this court and then an ethical complaint being brought to the responsibility board. And then they would have to make a determination on whether he should be suspended or disbarred. Would Maddox have to sue him? Maddox could bring the complaint, but so could another attorney. Happy birthday again and congrats on raising 5 kids, Lady Rackets.
Thank you. I don't know if I raised them yet. But...
Just run straight for president like the Donald. The dickheads can put you in office. Right now, I believe the dickheads can put anybody anywhere they want. The force of the fan base is insane. And Lady Rackets, I have a week-old newborn. Any advice?
Sleep.
Sleep when you can, buddy.
Sleep whenever you can.
Is Maddox going to jail? I don't think so, but Wouldn't it be fun? Hey, Lady Rackets, you're the prize. Rekieta Law was just shy of deserving, and I love that dude. Would you review a case where a college football coach sues the state, but the state is hiding behind sovereign immunity? Sure. If you have links to it, send it to me. Gas, couple lines of "Can you feel the love to please?" That's for you, I think.
No,
They didn't even ask me until you came on the stream. When Lady Raggeds decides to leave the stream, will she crawl away again? I think she'll walk away proudly this time.
I could try. I really want to do like the stare thing, but I'm afraid that I'll do it bad.
How did you trick Lady Raggeds into marrying you? It was a very long process of me being extremely persistent. Probably criminal, right? Like, I think these days. And very annoying. Yeah. The fleeing the interview thing is a famous quote from the movie Fargo. The character has an accent similar to you. Okay.
Oh.
How
See,
much?
I've never seen Fargo.
How much to pull out the whiskey? That's a good question. I was trying not to drink tonight, but I do have some sample whiskeys to try, so I'll also take the Circle of Life. Just a second, Gats. Lady Rackets' hair is really nice tonight.
Oh, thank you, Andrew.
Is there anything you can't do, Nick? Probably. I can't get She says no. I can't get warm without getting itchy. There you go.
That's true.
You're winning. Maybe you can do a stream on how to get a beautiful wife and a successful career.
Does he have a successful career?
I guess. Ooh, rude.
Gauntlet's thrown.
F. Kyle Risk. Coach Cake says, say who the fast risk CK is David Clegg.
Fast risk. That's nice. I liked how you did that.
Yeah. Elvis or the Beatles? Elvis.
You just hate the Beatles.
Not a fan of the Beatles. Would it be worthwhile for the dickheads to fund a Maddox case against Landau so that Dick could cover it without being on the chopping block? Oh, man. Maybe, but do you really want to help Maddox at this point? Stop the stream and go watch Fargo with Lady Rekieta. Can't pull out, apparently. Apparently bad at it. Ersk. That
one took me a long time. I'm like, what?
I'm a biotech engineer, good on the career, not on the ladies. Well, I'm not good on the ladies either. Just one. You have to find someone who appreciates just how nerdy you are. And I have mine, so stay away. Is there a constitutional right to privacy, and was Griswold versus Connecticut correctly settled? I'm not familiar with Griswold versus Connecticut. Constitutional right to privacy, insofar as the Fourth Amendment, I think so. If you're talking about Ninth Amendment right to privacy, I have problems with how they reached it in Roe versus Wade, so I don't know. That's a tough question. I'm probably going to do a stream on privacy and search and seizure at some point. Or not a stream, but a video. I stepped in my neighbor's dog poop right before walking in, like immediately before. Can I sue her for at least 20 million? Yes. You guys are really good singers. Can you welcome a new listener? Her name is I'm a G.
Welcome, I'm a G.
Can Landau sue Maddox for making a fool of him with a case this ridiculous, or the grounds that he was lied to or something? Not really. Have a good night. Gonna crash. Don't want to be late to work again because I stayed up to watch your stream. No, yeah, man. Don't be late on my behalf. Get some Z's. If I searched and seizured your room, what would I find? Rekieta Law. Have you seen this room? It's a disaster. I don't even know what's in here. Keeps skipping my questions. What did I miss? Did you tag me, Jordan? If you don't, okay. What do you think of the most recent Star Wars movie? I haven't seen it yet. We wanted to get to the theater, but with all the kids, it's hard to see. If I'm not, what's the legality behind scarification and body branding marking? I think that would be state specific, but I don't see any particular problem with it so long as it's consensual. Yeah, if you want me to answer your questions, Jordan, tag me with the @Rekieta Law, because I just didn't see them. Thoughts on Weird Al's I'll Sue You? I don't know if I've heard that song, but I'm going to see him live very soon, so I'll tell you once I do that. Do you follow anyone besides Dick, other podcasts on the network, Peach's streams perhaps? I've not had the opportunity to watch much of Peach's streams. I want to, but I haven't had time to. I used to listen to Asterios' stuff, but I ran out of time for that. I try to listen to Larry's show whenever I can, and here's what I don't get. Let's see. Other podcasts off the network, I listen to The Bible for Normal People, which is a really, really good show with Pete Enns. And if you know who Pete Enns is, that'll tell you a lot about it. I listen to Hardcore History with Dan Carlin, but he only puts those out like every 6 months, so that's easy. And I try to listen to Common Sense by Dan Carlin just to listen to him constantly baffled by Trump's presidency, because that's funny. What are the chances of the judge ruling in Maddox's favor out of sheer pity? I hope zero. I don't know. Favorite video game? What's your favorite video game?
Oh, I don't know.
Battletoads, buddy.
Oh, Battletoads is good. I like to watch Battletoads. I'm not good at playing.
Nintendo NES Battletoads. Has Miss Rekieta ever done a gnarly skateboard move? Do your kids like skateboarding?
Anytime I step on a skateboard, it's gnarly.
It's gnarly, but usually results in injury.
I was kidding.
And our kids do not skateboard currently.
Our kids can barely walk.
What's the legality of prank phone calls? I would have to really look into that on a state-specific level. So I don't want to give you an answer. I don't know. Would you be willing to do a dramatic reenactment of the LoLsuit transcripts? Sure. Yeah, I think that'll be funny. And internet popular because I love Clay so much. Sure, Clay. If you weren't a lawyer, what would you be doing? Sitting around my house, not being a lawyer, and having lower stress and spending more time with my kids. Who is more religious, you or Miss Rackets? Ooh, that's a good question. I don't know. I think we're probably pretty similar, but maybe in some different ways, and our focus is in different areas. No love for Battletoads for Xbox. I haven't played it, unless you're talking about the Rare Rewind. What do you want in your Mega Man level? Oh, man. Difficulty. Ramped up difficulty. How's that? I'm sorry, Peach. I watched one of your Let's Plays on YouTube, but I have to get to more. But I've been drowning my life in creating my own content right now. So I barely listen to the Dick Show at the moment. Don't tell anyone. Can you sue someone for leaking an email exchange as an invasion of privacy? Probably state specific. That'll involve the question of like captured wire communications, and it'll depend if it's a single party consent state or a two-party consent state. Do you do any mountain biking out there? I do not have a mountain bike, but I kind of want one. I think this format works better. I think so too. Ever read Marcus Aurelius? Because you should. I will. I actually have some of the classics on my Kindle. I just haven't had time to read, much lately. Favorite fictional movie? I said before American Beauty, I think. For Lady Rekieta, what's your everyday shoe?
My everyday shoe? Well, right now it's boots, because Minnesota / I just wear anything booty. Booty? Can I? No. Yeah. Anyway, I wear a lot of boots in the fall, winter, and spring here in Minnesota. In the summer, I wear a lot of sandals, flip-flops. I love a high-heeled wedge, because you might not know it from looking at me, but I'm not very tall. I'm about 5'3", so little.
Okay, Common Sense by Carlin Facebook group is horrible. I completely expect that. I got stitches in my finger 6 months ago, and it still hurts sometimes. Could it be infected, or has it been too long? Being parents makes you a medicine as far as I'm concerned. Man, if it still hurts from 6 months ago, I'd get it looked at.
I would definitely get that looked at.
I'm nearly 28 now. Am I too old to start studying law and get a good job? No. No, go for it. If you have an undergraduate degree, it's easier. If you don't have an undergraduate degree, expect to spend like the next 7 years in school. But if you have an undergraduate degree, yeah, go for it. You can do it. I just can't wait to be queen. We got to get some.
My queen.
Yeah, my queen. Guys, we've trained our 2-year-old to say, "My queen, do you know the way?" So that's
I love when they call me my queen.
We do have to get Gats. We have to get him some lines of a song. He super chatted for it. I mean, we owe it.
I know.
It's an obligation. What is your honest opinion on the outcome of all this? And also, I wish you and your family the best. Thanks, buddy. I honestly think it's going to be dismissed against all parties. The only outcome I see that's different than that is maybe not a dismissal against Asterios, which would be unfortunate, but I think he would go on to win on the merits. Make that pretty lady dinner. We already had dinner, guys.
It's bedtime.
It's 1 a.m. I'll Sue Ya is track 4 on Straight Outta Linwood. You've definitely heard that song. I mean, you say definitely, but you're like my parents when they tell me I've definitely heard music, and I haven't. 5'3", you got a jackpot. I agree.
Nick is not a little. He's
No,
6'2".
I'm 6'2".
I look weird.
Love it. Great. Thank you. You two are great. Love you too, Lydia.
Love you.
Thanks for being a fan of the show from the get-go. I do remember. I've seen you in the chat before. Lady Rackets is my queen by proxy. We need a clip of Junior saying, "Do you know the way?" I'll see if I can get a recording of her. I don't want to put her on camera for, various privacy reasons, but I'll see if I can get an audio recording of it for you guys. How does recovering for attorney's fees work in a dismissal? You ask the court for the attorney's fees, and if there's ground in New York, my understanding would be there has to be some sort of sanctionable act for those attorney's fees, and the court can make that decision on its own, or the parties can ask. And I think in this case, there's merit to that. How far have you actually gotten in Battletoads?
This is my favorite
Oh,
question.
buddy. A friend and I have beaten Battletoads 2-player.
It's impossible. but I've seen it
2-player.
done.
So we have gotten all the way through it. Cock launch. Have another kid. Thanks for doing the streams. Thanks, buddy. Streams are tons of fun for me, and I'm glad you guys enjoy them. All right, we should figure out a song real quick to sing just a couple lines of, and then probably wrap this up because it's we're pushing towards 2.5 hours.
I don't know. You make me sing at 1 a.m.
Well, I've been talking for the past 2 hours, so how do you think that's going to go? Who pays for attorney's fees, the attorney or the plaintiff? It depends on what the judge awards. If the judge finds wrongdoing from Landau, in theory, he could award attorney's fees against, from Landau or the Landau group as a sanction. How many tens of thousands of dollars have you lost since Jesse made his hit piece vid on you? Absolutely zero.
That's not what I was laughing at.
Oh, what? What's
It was
this?
Neil. He knew. I was waiting to see if
How did you get past Klinger Winger with 2 players? Neil, you know the answer to that.
You know the answer. It's not possible.
I
is it?
died and had to wait for my buddy to beat Klinger Winger, and then I would come back in for the tower. So I'm glad you know the answer.
You've just proven your worth, Neil.
Good job. You and your family are wonderful people. Set an amazing example for religious people from an atheist. Well, thanks, buddy.
Thanks.
We appreciate that. Fake news, Battletoads has literally broken the NES on cooperative. I know. We just addressed that. As a client, how can you deal with the law on a corrupt country? How can you deal with the law on a corrupt country? Assuming you don't have tons of money or the contacts for bribes, you can't. Sorry, bud. We now know you are not a manlet. Everybody in Chicago should know because I was there, and you can see my tallness.
I like this one. It's not a challenge.
If the kids stand on each other's shoulders, are they taller than Lady Rackets? I think so.
It might be. A Christian is quite tall now.
From the Good
We're not supposed to
Samaritan,
say names.
you have a beautiful family. Keep on keeping on. Thanks for the stream. Always a pleasure to watch. Have a good night. You too, Fuzz Got Games. And with the lawyer, etc. Okay. How do you deal with a lawyer on a corrupt country? Assuming you don't have the tons of money or the contacts for bribes. I don't know. I don't know how to answer that question, man. Here we can't, we can't deal in bribes or anything like that. And there is corruption that we have to deal with. And unfortunately, you just have to try and beat it. And that's just how it goes. Thanks, Bookham Dano, for the super chat. Hey, I like this live stream format with docs up front and Q&A. Q&A in the back. Please keep doing it. I think we will. Michael Fee, my birthday is in 8 minutes. Can I get a happy birthday from you and Mrs. Rackets?
I could do that.
We do happy birthday. Sing My Heart Will Go On. Yeah. You should do that.
I don't remember how does it start?
Every night in my dreams, right? I see
Is that
you.
the one?
I feel you. Yeah.
It's been so long since I've heard this song.
Can we do a Battletoads live stream when Maddox wins? No. He's not going to. He's not going to.
You're right.
How likely is it that Maddox might have to pay some glorious sanctions? At this point, I think it's, more likely by the document, including each one of these letters. Has your exposure to YouTube and TDS positively or negatively affected your firm? Neutrally. I live in a really small town. Like my advertising and networking is pretty much person to person, word of mouth. So, people like to, they like to check out my YouTube channel when they see it, but that's about it. If I get caught pirating online tutorials so I can learn to get a job in a certain industry, can I claim self-defense in court? I don't think so. Who wins in a fight, Jesus or Poseidon? I guess Revelation Jesus is pretty tough. He's got a sword in his mouth. That's kind of weird. Yeah. Poseidon, though, man, he's got the power of the sea. I don't know if they would fight. I think Jesus would probably talk his way out of it. Do you remove snow with a shovel or a snowblower?
We're spoiled.
Someone else removes snow for us. Our driveway is far too long. Have you followed the Brittany Pettibone and Lauren Southern UK stuff? Yeah, I have seen it. I haven't really been following it, but I'm shocked that the UK would block commentators that they don't like from entering the country. And that's just, something to be proud of in the United States. Those things are dwindling away, but the fact that we probably wouldn't turn away a national who's not suspected of some sort of terrorism because of the wrong think is a good thing. Law doctorate, whatever, but beating Battletoads deserves mad respect. Thanks, buddy.
That's not the Mike Leone we know, is it?
No.
Okay.
No, I don't think so. Mike, you're not the Mike that we actually know, is it?
You're not Big Mike, are you?
Because we know a dude named Mike Leon we went to college with. His name was Big Mike to us. If that's you, that'd be great.
That'd be hilarious. We haven't seen you in years.
Okay,
like, too many.
Go ahead and... All right. Okay. If you get too sick to stream, will you coach Lady Rackets to guest host? Sure. I'm a business owner. Curious, do you do lots of networking at a chamber for a new business? I am a member of BNI. That's where my networking goes to. The chamber, they have meetings early morning on Friday, and I don't do that. I'd watch a Count Dankula case cover. England is common law, so it can't be that different from American law. Yeah, we'll definitely check that out. Look at this guy hiring Mexicans in the dead of winter. They're not Mexicans.
They're a couple teenage boys.
Gats. No. Don't leave yet. If you're still there, don't leave yet. We'll do it real quick. Okay.
What are we doing?
We gotta sing something for Gats.
What are we singing?
I don't know.
Pick something.
Pick what?
Not Disney.
Not Disney?
I don't know.
Well,
People didn't like
what did we do?
Disney.
Oh, they're fine. I'm not the same Mike. Okay. We gotta.
You're still cool.
What do we got? What do we got? I don't want to start. You start.
I don't know what to start. It's hard to start a song a cappella, isn't it?
I had to do it last time.
No, not Moulin Rouge. Oh my gosh.
Time of my life, Evita. They love the Disney. Gary M. Yeah, I'll do Count Dankula's thing.
They're saying Titanic. I can. Seasons of Love from Rent.
Oh, we could do. Let's do. You know what I'm talking about.
Yeah, I do.
Okay, you're Angel.
I'm thinking. I don't know all those words.
Live in my house.
I know that.
We only need like 3 lines.
3 lines.
Something.
Live in my house. I'll be your castle. Shelter. I don't know.
Oh,
see, I told you.
Guys, it's embarrassing. Just kidding. Go. I'll be your shelter. Just pay me back.
Yeah. Just pay me back with 1,000 kisses. Be my lover, and I'll cover you.
Open your door. I'll be your tenant. Don't got much baggage to lay at your feet, but sweet kisses I've got to spare. I'll be there and I'll cover you. Oh, I'm slipping into the reprise. Sorry.
That's the reprise. We're done.
Okay.
Wait, though.
What?
We have to sing happy birthday. Who are we singing happy
Oh,
birthday
yes.
to? 'Cause
Happy birthday.
It's exactly that time.
Happy birthday. We've been waiting for it. Michael Fee.
Michael Fee.
So you got to start
Michael. That. Just regular, or are we? No, just kidding. I am not Marilyn Monroe. Happy birthday to you.
Happy birthday to you. Happy birthday, dear Michael Fee. Happy birthday to you.
Michael Fee, huh?
Best song ever for Haley. Thanks. Thanks, man. And no, we did not meet at singing camp.
No.
That's a story for a different stream before Lady Rackets blabs it.
Oh, no, I was just going to say he couldn't get into choir.
Nope. They threw me out.
They would not.
Did
let
it hurt
him
when
into
Lady
choir.
Rackets fell from heaven? She is the only 10 I see. Same, buddy.
You're so sweet.
All right, guys. We're going to wrap it up. It is 2.5 hours. It's 2.5 hours. Thank you so much for hanging out. I really, really appreciate it. And thanks for contributing to the super chats and the follow-up chats. We'll probably pursue this format going forward, unless it's just a completely open Q&A. We'll be in touch. Do expect a stream on Friday if you have suggestions for what to cover, assuming documents don't drop, since they're not due until the 27th. Please let me know. Although we may see some response to this before then. I doubt it. They technically have until April 1st, but it's possible. If Greenberger's like angry enough, he might do something. I don't have any idea how I keep up either, brother. All right, I'm fading the screen to black because I am worn out, and once it goes black on my end, I will stop the stream. You guys have a great night. Peace. Oh, keep it lit, keep it 100, fams, and trill AF. You do know the way, and
You do know, dude.
and keep it real, my dudes.